All right, good morning, everyone, and welcome to the April 2023 hearing of the Planning and Zoning Commission. I'm Greg King, Chair. If everyone would please join me in Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, to the republic for which stands one nation under God, indivisible, with liberty and justice for all. All right, so we're going to get used to some new electronics here. And while we're speaking of new electronics and old electronics, everybody please join me in setting your electronic devices to silent for the hearing. Thank you. First order of business would be approval of minutes. Can I go ahead and get a motion on the floor?
So move.
Mr. Elder, thank you. Do I have a second? Or excuse that second from Mr. Marsh. Do we have any corrections, questions? Ms. Jones.
Few minor corrections. On the first page, I believe the term would be sitting on the board. It's the second from the last paragraph. Would it be sitting on the board or setting?
I would think that to be sitting.
Yep. Got it.
On page 3 of 29, in the fourth paragraph down, the math just doesn't add up where it's got 17,000 square feet and 1,000 square feet for the county clerk's office, and says so the library will be 16,100 square feet.
Actually, what she said, believe it or not, there was some discrepancies, and I just left it the way she
Leave
said
it the way she said it. Okay.
Really, it's 16,000 square feet, not 16,100. So it's 16 plus 1,000 is 17, but that's the way she said it in that hearing.
On page 13, the permitted uses on the bottom of the page, agricultural uses is twice.
Yep.
Where it says public picnic grounds, bridle and bicycle paths, should those be together or separate bullet points? Doesn't seem like they go together.
Those are three different, well, public picnic grounds is one item, and bridle paths and bicycle paths are separate. So
Be a separate bullet point instead of there with the public picnic grounds?
that's not the way it's written in the proposal from the applicant, so.
So just leave it like that, okay. And then on the next page, still at the top, it's just got special. Does that need any clarification, or does special have a definition?
Probably just needs to be stricken, right, sorry.
Okay, and then also under conditional uses is agricultural uses yet again for the third time. I don't know if it goes under conditional uses or permitted uses.
I'm not clear either. I think, Christy, that's probably exactly the way they wrote it in the proposal. So, although it probably shouldn't be a conditional use, that's the way they had it in there, and that's the way we approved it. So let's leave it for now, and I don't think it's ever going to be an issue. I'm not sure what their thinking was, but
That's all you have? Okay. Anyone else? All right. I've got a couple. Page 15, middle of the page. We have two references to legislated body. That should be legislative in the middle paragraph. That's all I got. It should be legislative, and that all should be legislative. Go. All right, anyone else? All right. We'll go with a voice vote on approval. All in favor of the minutes as corrected, please signify by saying aye. All opposed, like sign. Motion carries. One abstention. Thank you, Mr. Thank you. All right, so first item on the docket. Ms. Edgar, will you read the docket for the first item, please?
Docket PC 23009, an application has been filed by Creek Alley Properties LLC for the approval of a development plan and zoning map amendment on approximately 0.218 acres. The property is located at 107 East Washington Street, LaGrange. The proposed change is from R4 Residential District to CN Commercial Neighborhood District.
And Mr. Fisher, whom you'll be presenting?
Yes. Do we want to get everybody sworn in?
Absolutely.
Do solemnly swear to tell the truth, the whole truth, and nothing but the truth.
Do.
All right. Ryan Fisher, Senior Planner with Oldham County Planning and Development, 100 West Jefferson. So this item on the docket is for a zoning map amendment corresponding development plan for 107 East Washington Street, just a few blocks away from here. So the proposal and application has been filed by Creek Alley Properties, LLC, for the approval of a development plan and zoning map amendment on approximately 0.218 acres. Property is located at 107 East Washington Street in LaGrange, and that change will be from an R4 residential district to CN Commercial Neighborhood District. Here is our site information, once again showing your existing and proposed zoning on that 0.218 acres of property. No previous site history. Case history, there was a neighborhood meeting held on March 20th. Just for clarification purposes, there was nothing included in your staff packets about the neighborhood meeting solely because nobody showed up. So really it was just a blank agenda page with the four individuals that were there representing the applicant and nothing else. So it was posted to the website on the 29th of March. Our adjoining property owner notices were mailed on the 6th. We had a sign posted on the property on April 11th, and the public notice appeared in the Oldham Era on the 13th of April. Here's a picture showing the posting of the sign in front of the property on April 11th. And here is the property in question, 107 East Washington, in between Walnut and First. And here is your zoning map currently, showing R4. And then our future land use map showing that this particular parcel would be commercial in nature. So the applicant is proposing a zoning map amendment to change the zoning from R4 residential to commercial neighborhood on that 0.218 acres of property. Proposed development will be mixed use with retail on the first floor and residential unit on the second floor. Now that property has previously been used as a mixed use, and the applicant is requesting the zoning change because the current zoning classification is considered inappropriate. The purpose of the commercial neighborhood district, and this I believe was included in at the rear of your staff report showing just the commercial neighborhood zoning regulations. The purpose is to promote the reuse of structures located in urban areas of Oldham County that have been constructed for mixed commercial and residential use, which may be currently underused or vacant, and which are located at street corners or on blocks with a significant number of retail business uses. So that comes directly out of our zoning regulations, which once again is included in your staff packet. KRS 100.213 talks about the findings necessary for a proposed map amendment, and I've highlighted here on your screen item A that states the existing zoning classification given to the property is inappropriate and that the proposed zoning classification is appropriate. And I'm sure the applicant will talk about this a little bit, but in their justification statement, they pretty much talk about that's the reason behind the zoning map request is that the current zoning classification being inappropriate. Here are just some pictures of the property looking at it from the front on East Washington Street. Here is a picture from the corner looking down the alley. Another picture looking a little bit more towards the alley, even though my map sort of blocks the alley a little bit. from the other side, and then a photo from the rear of the property looking at it from the alley. So the proposed binding elements we're looking at here is the approval applies only to the plans presented at this April 25th, 2023 Oldham County Planning Commission public hearing. There shall be no changes to the plan without review by the Oldham County Planning Commission and Engineer's Office, and the plan must comply with all established federal, state, and county ordinances and requirements and comply with all necessary easement restrictions at the time of construction plan approval. And as always, the Planning Commission, you can amend, delete, or add additional binding elements at this public hearing. So in summary, the applicant is requesting that zoning change from R4 residential to commercial neighborhood district on 0.218 acres of property at 107 East Washington Street in LaGrange. This obviously with the zoning map amendment would be a recommendation to the city of LaGrange. And then the applicant is also requesting approval of the corresponding development plan that will go along with that zoning map amendment. So with that, if you have any questions.
Thank you, Mr. Fisher. Does that conclude staff's presentation? All right, questions? Mr. Douglas.
Ryan, I have one question about, I noticed it on the or the plat. They indicate they're talking about proposed parking in the back.
This might be a question for them.
No, I mean, does it meet the standards of our commercial for parking per square foot of this building?
Well, it really doesn't. These are old downtown parcels. Even all the restaurants, none of them have parking. So it really never can, quite honestly, because there's on-street parking that's not dedicated necessarily to a use or to a building. So providing additional parking is a good thing. That will help alleviate some of the downtown parking issues, but nobody downtown has adequate parking.
I agree. I was just wondering, since they have proposed that, are they required now to designate one of those parking spaces as an ADA handicap parking?
You can ask them if they intend to do that. I would hope. The difficulty is the buildings are historic and they do not actually have to be ADA compliant. So whether there are sidewalks, whether there's access into the building that's ADA compliant, we can ask the applicant.
Mr. Douglas, that all you have? Okay. Further questions? All right. Being none, we'll move into presentation from the applicant.
Chairman, members of the committee, Mr. Urban, Mr. Baxter, Ms. Edgar, good morning. My name is Mike Swansburg, and I'm an attorney with the law firm of Swansburg & Smith. My office is actually here in LaGrange, located just across on West Main Street. I'm not sure if I need to be sworn in this morning. If so, I'm happy to do that, just for the purpose of talking as well, but that's a formality I'll certainly defer to you all on.
Do we swear, counsel?
Necessary.
Fair enough. But members of your team who will be providing testimony, yes.
In addition to myself this morning, I've got Bob Van Sant, and who's with Van Sant Engineering. He's the engineer on this project. Also, Max Onan is here with Creek Alley Properties. I don't necessarily anticipate Mr. Onan speaking, but I just wanted to let you all know that he is here on behalf of the property. Mr. Van Sant will, I suspect, talk about some of the technicalities. So if we want to, Mr. Chairman, go ahead and have him sworn in.
Go ahead and get the two of you sworn, just in case.
Solemnly swear to tell the truth, the whole truth, and nothing but the truth. Thank you.
Thank you very much. Ladies and gentlemen, Mr. Fisher did an excellent job going over the highlights of this proposed project on behalf of Creek Alley Properties. I do want to expand a little bit upon that and just provide a little more information from our perspective as to why we are seeking this amendment this morning. And of course, as a lawyer, I was going to start with what is the law in this case. Mr. Fisher actually already highlighted that this morning, but I want to just reiterate it for the groups, for the commission's purposes this morning, and that is Kentucky law, specifically KRS 100.213 subsections 1A in particular. So KRS 100.213 1A in particular says that before any map amendment is granted, the Planning Commission must find that the map amendment is in agreement with the adopted comprehensive plan or in the absence of such a finding, that one or more of the following apply. And subsection A then says that existing zoning classification given to the property is inappropriate and that the proposed zoning classification is appropriate. So in our case, we would actually argue there are 2 points to be utilized in support of this program. One is we would argue that it actually comports with the comprehensive plan, and I'll get to that in a minute. But in addition to that, as Mr. Fisher pointed out, the existing use of the property, the long time existing use of the property, more than 20 years of existing use, has been in a mixed use context, which quite frankly is inappropriate for the current zoning designation, which is R4, which is multifamily, for example, apartment buildings and that kind of usage. And so what we would say is that for the purpose of today, there are really 2 bases from our perspective as to why we think that this map amendment is appropriate from a legal perspective. And one, of course, is that it comports with the comprehensive plan. And let me discuss that real quick from our perspective. And we actually included all this in our justification statement, which was part of the packet, but just again to reiterate, it comports with the comprehensive plan. Specifically, we would argue land use objective LU 2-1, which talks about establishing a neighborhood development guidelines that promote connectivity between neighborhoods and encourage integration of community and civil facilities and address issues of neighborhood identity and compatibility with adjacent development and assure that adjacent development is sensitive in both design and environmental impact of historic sites, neighborhoods, and districts. Specifically, there's a subsection 1 of that which identifies as a sub-goal the, quote, encouragement of new mixed-use development in addition to existing mixed-use centers and planned unit developments. And as Mr. Fisher already talked about, and as we'll go ahead and point out and is included in your packet, this project is designed to recognize an already mixed-use property. There is retail use on the first floor, residential use on the second floor, and it has been that way, as far as we know, for more than 20 years. And this, as our opinion, meets this objective squarely. Again, this mixed-use concept. In addition, land use objective LU 3-1 talks about supporting existing businesses or business retention and growth compatible with adjacent land uses and the availability of community facilities and services. So again, supporting existing businesses. And this project is designed to support existing businesses we would submit by providing a space for another, again, a retail concept, one that is either has already exist or additional retail concepts in the future, the goal of which would be to draw residents not just from the area, but from outside the area into the downtown LaGrange area. And that is already just a couple of blocks from what we would submit as an already vibrant thoroughfare on Main Street in terms of retail space. And so we're talking about adding an additional space, just merely a block or 2 from downtown on Main Street, that will entice people or encourage more people to come downtown and utilize all the great resources and avail themselves of all the great retail shops and restaurants that we already have here in the city of LaGrange. So it actually is intended to support what is already here. In addition to that, we would submit that business and industry objective BI-2-2, which talks about protect and enhance the historic character of the cities here in Oldham County. This project is going to retain, as you've seen in the pictures and is noted on the map, the project is going to retain that early 20th century home that's already on the property, the main structure, that red building that you all might have seen in the pictures. And there's going to be a minimization, little impact on that structure in and of itself, and will do really nothing to upset that traditional, that inviting look that really draws people here to LaGrange. Again, that neighborhood feel that you've got where you can come in and avail yourself again of a retail space, but you don't feel like you're in a big block concrete space that you might have in a bigger area like, say, downtown Louisville or something to that effect. So we really want to make sure that we're retaining and maintaining that neighborhood feel that is pretty integral to the spirit, really, of what the city of LaGrange is about. So again, we would submit that those are the bases through the comprehensive plan that support our request this morning. But in addition to that, as we talked about, obviously, and as I've already mentioned, really is that mixed-use concept. And as right now, the property is zoned, as Mr. Fisher pointed out, R4, again, which is multifamily, apartments, et cetera. And again, the current usage of the property is mixed use, which is really what that CN designation is about. And it specifically talks about mixed use. And so we believe that a change in the zoning map from R4 to CN is going to meet the existing use of the property and really essentially correct an error. And it's not anyone's fault per se. It's just an oversight for many years that no one really picked up on, that we think at this point this commission has an opportunity to address and correct, and hopefully the city of LaGrange does as well. So with that, that's an overview, particularly from a legal perspective, and a justification for why we would submit this change to the commission. And I'll be happy to ask or answer any questions you might have from that perspective, and also have Mr. Van Zandt come up and talk about any technical requirements. I know there was a question about parking before. Mr. Van Zandt and I talked about that. For example, the available street parking actually right in front of the building right now is already ADA compliant in the context that there are ramps that already go from the street onto the sidewalk there and right into the building. So we believe that there is an adequate parking space there for that purpose. But if there are any other questions from a technical perspective as well, Mr. Van Zandt would be happy to answer those.
Thank you, Mr. Swansburg. We'll get to those in a few. Does that conclude the applicant's presentation? Mr. Vincent, please.
Morning.
Name and address for the record, please.
My name is Bob Vincent. I'm with Vincent Engineering and Land Surveying, 1000 Cherrywood Place, Suite 200, LaGrange. I am a licensed land surveyor and a licensed professional engineer in the state of Kentucky. I might need a little help here. I'm going to try to get my plat.
Jay does.
Got to wait a second for it to come up. Yep.
That's right. All right.
Sorry.
All good. Thanks.
Okay. As Mr. Fisher and Mr. Swansburg have already presented, they did an excellent job of going over most of the details, but there's a couple technical things that I would like to mention. Again, we've got a little over 2/10 of an acre on this existing parcel. There's an existing 2-story frame. There's an accessory building to the south that's just used for storage, and there's no intended improvements to this property except for the 4 parking spaces here that we've already discussed. The requirements for the C commercial neighborhood zoning, and also based on the square footage, would be a minimum parking of 7 spaces. So you can see, if you look on the plat, there's all kinds of existing parking along East Washington Street here and here. There are 3 parking spaces that are located immediately to the north and adjacent to our property. Our client would like to possibly build 4 parking spaces on the property that would be dedicated, obviously, for use in this property. If you take the 4 and the 3, add them together, that would be a minimum of 7. But like Jim said, in downtown, parking's woefully inadequate. But we feel like if we do those 4, that we're doing about the best that we can with the property. If you allow us to do those 4 spaces, the impervious surface would be in the neighborhood of 20%, and in this zoning area, you could have 85%. So we're nowhere near approaching the maximum impervious surface for the project. On the south side of the property is the one lone non-commercial lot. It's zoned R4. I believe there are apartments that are located back there. So if we were to be granted this zoning change, technically when we become commercial, we would be abutting a residential district. So we would need to put in a 15-foot perimeter landscape buffer area that would be located right here. And I did want to mention that to the south, on the south boundary and at the southeast and southwest sides, there is an existing privacy fence. So that would help with the buffering back there. There's all existing utilities in place. Obviously, this is a very old structure. There really wouldn't be any noticeable disturbance in the area. Just again, like we said, we would like to have those additional 4 parking spaces if we could be granted that. That's concludes what I got to say. Thank you.
San?
Mr. Chairman, with that, unless there are any further questions, that actually will conclude our presentation on behalf of the applicant.
Mr. Swansburg? Is there anyone else here present who wishes to speak in favor of this application? Anyone wishes to speak in favor? Very well. Moving along into those wishing. Thank you. Anyone wishing to speak in opposition or ask questions of this applicant? All right, there being none, Mr. Swansburg will move into your final statement, please. Oh, excuse me. I'm sorry. Let's go to questions from the commission first. Thank you. Yeah, there you go. Nasser, you have a question?
I do have one quick question. What is the current use of this property?
And obviously can speak to that more for me. My understanding is there's a salon on the first floor and there's actually an apartment on the second floor right now. So it's already in that mixed use stage.
This is borderline on testimony, but I got to explain how this came up. There has for a long time been a beauty shop on the property, and the previous beauty shop owner either retired or left the property, and a new one wanted to take their place. When there are about 4 different land uses that require a signature from the planning office that the zoning is appropriate. Daycares, beauty shops, nail salons, car dealerships. I think there's one more. When the owner came and said, hey, I want to get this signed by you, I researched back in our regulations, in our files rather, and to find out how did this first beauty shop get there under the R4 zoning. And there wasn't any indication whatsoever, and I couldn't remember. It goes back a long time. So that's how this rezoning application came forward. So it has long been used as a beauty shop. I believe that it's intended to be a beauty shop, and they just need to get the zoning correct so that we can sign that form.
Question from Mr. Urban pertaining to that, maybe Mr. Baxter. As we make our motion, there's been a lot of discussion about the history of the facility. But as we make a motion, it'd only be going forward. In no way, shape, or form would we be saying that, what has been done in the past has any relevance here. Do we need to specify that in our motion?
I don't know whether, I think you have enough other testimony regarding the comprehensive plan, the land use map that predicted this to be commercial, and evidence presented by the applicant that you can rely on without even talking about the previous use.
But the previous use is obviously relevant. Certainly it's a fact. It's a fact. That's what so you need to base your motion based upon the facts and the testimony presented by the applicant and whatever Mr. Fisher may have said in his staff report that you think supports the request for the zone change, if that's your motion. Yes, sir. Thank you.
I do have one question. You mentioned the compliance of the building. Are there any handicap parking spots proposed here? I didn't see any set for handicap.
Proposed spots on the structure, on the spot, it's on the property itself.
Back, are you?
And can actually answer that question.
We are not proposing that one of those 4 be ADA accessible. Topographically, it would be a little bit difficult. We do believe that the on-street parking is the best available accessible parking or parking spots for ADA. Again, the the parking spaces that, you know, they're obviously along the road. If you go to the west, you could actually, if you're in a wheelchair, you could roll right onto the sidewalk, and then there's a sidewalk that comes into the front door.
That'd be a question for staff. Is there a requirement that there would be a handicap parking within such a distance of this facility?
Well, it's supposed to be the closest space to the entry, and testimony is that those on-street parking is the closest. So putting it in one of those four proposed spaces would be actually the farthest.
Thank you.
Okay. Mr. Douglas.
Let me just add, you know, if that became an issue for the operator of the beauty shop, they could petition the city to put up a handicap parking sign. If they had regular clients or a client that needed to have that accessibility, it's possible to get a sign on the street.
Mr. Douglas.
Mr. Vincent, Bob, I believe you already answered this, but I just want a clarification. You did say those 4 parking spaces that are proposed in the back is part of the calculation of the impervious surface with the structure.
That's correct, yeah.
What type of impervious surface you might be using back there?
I think it cannot be gravel, so I think it has to be paved by regulation based on the zoning. So it would be a paved parking surface, yeah.
Do you intend to have any, I guess, any runoff, stormwater runoff off that?
There would be a small amount of storm runoff. I don't believe we would have to, like, create a detention basin. I mean, it would be so small that.
Sure.
Would you take it? So I know Mr. Silliman could probably address that, but I don't think it would.
Thank you.
But thank you.
And since it is on a city alley, they'd have to get a encroachment permit from the city, and then they would be the ones who would ultimately determine construction materials and runoff.
Further questions from the commission? All right. Mr. Swansburg, let's move to your final statement now.
Members of the commission, again, I want to thank you all for the opportunity to allow us this morning to come in and talk with you about this proposal and to share our idea for how we can improve an already, again, vibrant downtown here in the city of LaGrange, and again, to come up with a concept and a plan that meets both the spirit and the letter, if you will, of the law here in Kentucky. And again, just as I started out with, the law in the Commonwealth of Kentucky in terms of approving a change to a zoning map provides essentially, in our case at least, 2 opportunities. One is going to be through a testimony or evidence that it meets the comprehensive plan for Oldham County, and then of course also testimony that the existing use is inappropriate, or I should say the current zoning application or designation is inappropriate for what the actual property is being used. And to the question before about whether or not we look to the past, I would submit that from our perspective at least, the looking back at the evidence of how the property is currently being used is relevant to the question of whether or not the current zoning designation is appropriate and whether it should be changed to conform with a more appropriate current usage. So that we would submit that yes, that is appropriate, and I believe that we've submitted testimony to that today, and hope that addresses those concerns. But again, we think this is, again, pretty straightforward concept. Appreciate your time as well. Appreciate all the questions that you have. Of course, at any time, if there is any additional questions or concerns, we'd be happy to answer those, whether it's from the commission, whether it's from the staff. And again, I do want to take this opportunity to thank, by the way, the commission staff, in particular Mr. Chairman, for their professionalism, for their expertise, and quite frankly, for their willingness to work with us as we work through this project and make sure we got it presented to you all today. So again, thank you on that front. Mr. Chairman, if it is okay with the county attorney, I actually did draft up a proposed motion, which I'd be more than happy to pass out.
Mr. Chairman.
To the members to hopefully make everyone's experience a little easier. Don't know, Mr. Chairman, if you would prefer I send it to anyone in particular first. I do have 20 copies of this. Again, county attorney is happy to tell me if I didn't do it correctly. And again, the idea behind this proposed motion is to set forward both what the law is in terms of our support, as well as the proof or evidence that would support that finding as well. So again, we would submit that and respectfully ask the commission to approve our application for a development plan as well as the change to the zoning map here in Oldham County. Mr. Chairman, with that, thank you very much. I appreciate the opportunity to speak this morning.
Mr. Swansburg. Okay, commissioners, we'll move into considerations now. Mr. Urban, would you care to frame this up?
Sure. As always, on the second page of your staff report, you have proposed motion for either approval or denial. This is a recommendation to the LaGrange City Council. Since it's a zoning map amendment, we're going to take that one first. This is a good opportunity for us to sharpen our motion-making skills, if you will. You've been presented with a lot of information. If you agree with it or not, that's up to you. There's a justification statement that's been in your staff report submitted by the applicant, including compliance with the comprehensive plan. The applicant has just proposed a motion for approval of the development plan and the zoning map amendment. We do two motions, so be careful about that. The first one is a recommendation on the zoning map amendment only.
And one comment I'd like to make, Mr. Chairman. Staff does an excellent job in the staff report in laying out the motions and findings, but understand that that is a framework merely for you to use, and you need to attach specific facts that you believe support either approval or denial of the zoning map amendment. And then when we get to the development plan, the same thing. So they've given you a framework. And from the testimony that you've heard today, you should point to specific things that you heard by testimony or in the staff report that you believe either support approval of the zoning map amendment or denial of the zoning map amendment.
Thank you, gentlemen. All right, we'll move into opening the floor for the recommendation on the zoning map amendment. Mr. Douglas.
Mr. Chairman, reference docket PZ-23-009. I make a motion that we recommend approval to the City of LaGrange of the zoning map amendment because, first off, it complies with KRS 100.213 that the property is inappropriate in the existing zoning classification and that the proposed zoning classification is appropriate to CN, and that also that it complies with the comprehensive plan of the Oldham County Comprehensive Plan of Land Use Objective LU 2-1, where it's established neighborhood development guidelines, promote connectivity between neighborhoods, and encourage integration of community, civil facilities, and neighborhood identity. And also subsection 1 of LU 2-1 expressly identifies as a sub-goal of the encouragement of new mixed-use development. Also, I would incorporate the land use objective LU 3-1, supporting existing business retention and growth compatible, and also a comprehensive plan objective B1-1-2, supporting existing business and industry to thrive and grow in Oldham County. And also with that motion, a recommendation to the City of LaGrange, I would recommend the proposed binding elements 1, 2, and 3, which is the approval.
That's on the development plan.
Sorry, you're correct. That's my motion.
Thank you. Council, do we have an adequate motion on the floor?
We do, Mr. Chairman.
Thank you. Look for a second. Mr. Marsh? All right, Ms. Edgar, we'll move into a roll call.
Mr. Douglas,
Yes.
Mr. Elder,
Yes.
Mr. Ender, Mr. Falvey, Mr. Finney, Mr. Hampton, Ms. Jones, Mr. Winters,
Yes.
Mr. Klingenfuss, Ms. Nasser, Ms. Walzer, Mr. Marsh,
Thank you, Ms. Edgar. And motion has carried by a vote of 12 to 0. We'll now move into the development plan. Mr. Urban. Development plan.
Sorry, he was whispering in my ear. This is not, this is a motion to either approve or deny the development plan, not the preliminary development plan, since it's an existing building and they're proposing just addition of parking. In your staff report on page 3, you have a proposed motion for either approval or denial. Here again, you can just add in, fill in the blanks with some of the facts that you might have heard in this case. There are 3 proposed binding elements. The first is the approval applies only to the plan presented at the April 25th, 2023 Oldham County Planning Commission public hearing. Number 2 is that there shall be no changes to the plan without review by the Oldham County Planning Commission and the engineer's office. Number 3 is the plan must comply with all established federal, state, and county ordinances and requirements and comply with all necessary easement restrictions at the time of the construction plan approval. I didn't hear any other evidence that might lead us to an additional binding element.
Thank you, Mr. Urban. Council, anything to add?
Mr. Chairman.
Okay, floor will be open for motions on the development plan.
Yes. Motion to approve the development plan from the applicant PZ-23-009 as it complies with the objectives and goals of the comprehensive plan and the zoning ordinance in the subdivision regulations, and inclusive of all of the proposed binding elements set forth by Mr. Urban.
Thank you, Mr. Ender. Council, do we have an adequate motion on the floor?
Ender, is that subject to the fact that we've got an existing property on, or existing building and structures on the property, that there's not going to be any change to that? So the development plan essentially is not really changing the use of the property? Incorporate that into the motion?
Yes.
Thank you, Mr. Ender.
Have an adequate motion, sir.
Thank you. We have a motion on the floor. Do I have a second? Mr. Finney, thank you. Questions on the motion? All right, Ms. Edgar, we'll move into a roll call vote.
Mr. Marsh,
Yes.
Ms. Walzer, Ms. Nasser, Mr. Klingenfuss, Mr. Winters, Ms. Jones, Mr. Hampton, Finney, Mr. Falvey, Mr. Ender,
Yes.
Mr. Elder, Mr. Douglas.
Thank you, Ms. Edgar. And the motion carries on a vote of 12 to 0. Mr. Swansburg, application has been approved. Next up, City of LaGrange. We'll close this hearing. Okay, and we will move into our next docketed item. Is everybody good before we jump into this? Everybody good to move forward? All right. Ms. Edgar, can you read the docket, please?
Docket PZ 23010. An application has been filed by Stuart and Linda Robinson for the approval of a road frontage variance with a waiver to allow another parcel on an access easement at property located at 2200 East Highway 42 LaGrange. The property is zoned AG1 agriculture.
All right, Mr. Fisher, you have the staff presentation.
That's me.
All right, sir.
Once again, I'm still Ryan Fisher, Oldham County Planning and Development Senior Planner. So as Ms. Edgar stated, this application has been filed by the Robinsons for the approval of two different things here, a road frontage variance, along with a waiver to allow a fourth parcel on an access easement at their property located at 2200 East Highway 42 in LaGrange. And as she stated, that property is zoned agricultural. Here's the site information on the property showing its existing zoning, its existing land use, and the acreage on 39.765 acres. No previous site history. Case history, we did post this to the website on March 29th. Adjoining property owner notices were mailed on the 11th, and it appeared in the Oldham Era on the 13th of April. Here is the parcel in question, 2200, and the existing zoning being agricultural. So the applicant is requesting a road frontage variance for a proposed 11-acre tract to be known as Lot 1 on their survey. The required road frontage for property zoned AG1 for 2.5 acres and larger is 300 feet. And in the rear of your staff package, you'll see those regulations, and then you'll see that here in a second on the presentation. So the applicant is proposing to create a new lot, which we will call Lot 1, provide a buildable lot for their child. In creating that new lot, it becomes landlocked with zero road frontage on a public right-of-way, therefore requiring that road frontage variance request of 300 feet. And that proposed Lot 1 is 11.079 acres. So here is directly out of our regulations showing the agricultural district and the minimum road frontage being 300 feet for those lots that are 2.5 acres and larger. So here is the proposed Lot 1 in the rear of this property. And then down here at the left, highlighted in yellow, you'll see that access easement that's gonna bring up access to the rear on Lot 1. The applicant will prepare a minor plat and a shared road maintenance agreement between all parties involved, and at this point have provided a signed and notarized letter of intent between all the parties, and that is included in your staff packets on the very last page, showing their intent to be able to create that. I think one of the parcel owners is a pilot who's frequently on the road, and so they were able to at least get that, but that will be in the conditions of approval as well, that they will have to prepare that minor plat and shared road maintenance agreement. And then the applicant is also requesting a waiver of the Oldham County subdivision regulations, section 5.7, item E, for the approval of that fourth parcel on an access easement. And here is section 5.7 showing there that no more than 3 parcels may take access from a single street encroachment, not considered a frontage street or private roadway. And so here is the proposed lot, and I'm sorry for the drawings here that make me look like I'm back in preschool or something, but I couldn't figure out how to do the nifty ones that Amy used to be able to do. So here is your proposed Lot 1 in the rear. In light blue there, which is very hard to pick up on my screen, so I'm sure it is on yours, but directly below is the second parcel, the residual tract of the land, and then in the front, the existing parcel there of the Robinsons. So those are the 4 parcels that are going to be coming off this existing access easement that will be right in this area. So in summary, the applicant's requesting a waiver of Oldham County Subdivision Regulations, Section 5.7, Item E, for the approval of that fourth parcel on an access easement. So that will be the first item that we will look at, and those conditions of approval are that waiver shall only apply to the plans reviewed at this April 25th, 2023 Oldham County Planning Commission public hearing. A minor plat application and survey must be submitted to staff for review and approval prior to the issuance of any building permits. And that shared road maintenance agreement shall be prepared and agreed upon by all parties affected and recorded with the minor plat. And then the second part, which the title slide up there should say road frontage variance, so my apologies. So the applicant is requesting a road frontage variance of 300 feet for the proposed new lot with 0 road frontage. So in summary there, the required road frontage for that agricultural zoning district is 300 feet. They are requesting road frontage to be 0, and so that variance requested is 300 feet. And the conditions of approval for that are that variance shall only apply to the plans considered today at this April 25th, 2023 Oldham County Planning Commission public hearing. And with that, Me or Mr. Urban will entertain any questions you may have.
All right, anything else from staff on this? All right, how about questions from the commission? I have one. This is for council. Do we have a procedure or a process where the road maintenance agreement is reviewed by council here? Is it subject to any review protocol?
Well, I've only been in the job now for 4 months, so I haven't reviewed one. So Mr. Urban, I know, will require them to submit a road maintenance agreement with that minor plat before they'll sign off on the plat. And that road maintenance agreement will have to be recorded with the minor plat.
All right, anything else on that the commission should hear?
Answer.
Fair enough. All right,
And it is a binding condition of approval, rather, if you choose to approve the waiver.
gotcha. Mr. Douglas, you had a question?
I do. Mr. Fisher, during the conversations with the applicant, and I'll ask the applicant also, but was there any conversation about why not just using, because I guess the residual track in the back, 26 acres, is theirs also?
That is correct.
Is there any discussion from staff? Why not just use part of the property instead of just going over to the easement on the other property so they wouldn't have to get the notice of intent?
The original idea was to come in this access easement. So when they originally came in and applied for this, they came in here. Well, there was another parcel that had been created that they missed. Didn't miss, but overlooked. So that was also going to require a fourth parcel on that access easement. So they decided then to come over here, and I think one of them is a cost perspective. You'll be able to ask them of that on why they didn't originally want to do this one originally. So they were going to this other access easement. I'm not going to answer it near as well as they can, but that's kind of when they came in, that was their original intent.
So
It doesn't make it any clearer.
Like you said, let the applicant explain.
just didn't know if you explained, or staff explained, that using the utility easement for a roadway, the consequences if that utility easement becomes more than a roadway, it actually becomes a utility.
It does say access.
Yes, and utility easement.
Okay.
So, and that really is it. This parcel is a subdivision of their land. So really, in the end, we've encouraged them to use their access and utility easement to get there.
And just to reiterate again, I know we've discussed it before in other letters of agreements between property owners. That goes with on the plat and the deeds, is that correct?
When they submit a minor plat for review, they have to also submit that access and maintenance agreement. And they're pretty typical, but they require signatures. So the biggest thing is we have templates that we use or that applicants use, and they're all fairly similar, but they all have to be in agreement.
Mr. Douglas. All right, Mr. Marsh.
The satellite image and the map, please. I'm not following where
This is their existing access here. The lot is actually a little bit farther off. This aerial image is where the proposed lot would be. So, from off of here. And we'll go back. You're welcome.
Oh, you have Mr. Marsh? Yes. Okay. Mr. Klingenfuss?
The access agreement, maintenance agreement, that's going to be recorded in the deed?
Yes.
With the other tracks, is it recorded in the other tracks that agree to the maintenance agreement?
It will need to be signed by anybody who has access from that easement, that they agree on maintenance.
So they have agreement, but it's not recorded in the other tracks?
It is.
Okay.
Recorded with the minor plat. I'm not sure if you're asking, do they have to go record something on top of somebody else's property? And the answer is you can't do that. I don't think you can record something over somebody else's
agree.
property.
My question,
Signing, if they're involved in the access agreement, they will sign off on it. If that's the way they gain access. If they don't gain access, then it's irrelevant.
concern is the other property is sold years later. Is that going to carry on to the future property owners?
Yes, the answer to that would be yes, and it should show up in the chain of title. So what would happen is that everybody who signs off on it, when you get on the ECLIX program, which is what how you examine the property records in Oldham County, it would show up as a matter of public record and for lack of a better term, an encumbrance on each property and their obligation to comply with the terms of the maintenance agreement.
All right, Mr. Finney. Okay. Further questions? All right, there being none, we will move into, thank you, Mr. Fisher, we'll move into presentation from applicant. Who would like to speak for the applicant?
Why don't you move down here so you don't have to walk down later?
All right, before you guys get going, we're going to get you all sworn in, and then we'll collect your names and addresses as you begin your testimony.
Raise your right hands. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
The floor is yours.
My name's Dr. Stuart Robinson. We own the tract that you see up on the screen.
Be sure you step close enough to there you go.
Better? Okay. We have 3 daughters. 2 of them want to build on the property that we own. We originally purchased 60 acres. We purchased that from Barry Moore, who lived next door. The intent was to have all 3 of our daughters eventually build out on the land. One of our daughters has no intention of building. Deborah Serlin, who owns the 10-acre tract underneath Lot 1, is our eldest daughter. She already owns that tract. Originally, we had a verbal agreement with the access way to come down the existing access way for our neighbour. We had a verbal agreement with them that they would allow that. And then we discovered that there was a wrinkle. There were already 4 tracts off that, so it needed an amendment, and that needs to be straightened out. We don't know whether we can use that driveway or not. So the advice was to simply extend the access way that we have to Deborah Serlin's lot to Lot 1, and that would make it more simple. So that's the intent. So the original 60-acre tract, just under 60 acres that we had, now has 2. Will eventually have 2 tracts that will be owned by our daughters, and the remainder tract we intend to keep as wild tract. It's about half woodland and half pasture, lots of deer, lots of turkey, lots of things like that, and we have no plans for doing anything else after this. We'd like to keep that as wild land.
All right, thank you. Anything else to add?
That's it.
Anyone else here wish to provide testimony in support of this application? All right, thank you very much.
Thank you.
Anyone present who wishes to speak in opposition to this application? Anyone wishing to speak in opposition or ask questions of this applicant? All right, being none, we'll move into questions from the commission. I think that's a first, guys. All right, no questions? All right, we'll ask you for your final statement and move into considerations. Please approach Mr. Dr. Robertson.
If you have one.
If you have one.
That I can add.
Thank you very much. All right. All right. Mr. Urban, will you frame this up for us?
We actually have two motions, and we're going to take them in, I think, order of significance. The first is for a waiver, and the waiver is to allow an additional parcel on an access easement. On page 2 in your staff report, you have a sample motion. There has not been a whole lot of testimony or evidence, but you still need to rely on some of the facts of this case in making a motion for either approval or denial of the waiver. In the case of the waiver, if you are inclined to approve it, there are 3 conditions of approval. The first is the waiver shall only apply to the plan reviewed at the April 25th, 2023 Planning Commission public hearing. The second is a minor plat application and survey must be submitted to staff for review and approval prior to the issuance of any building permits. And the third is that a shared road maintenance agreement shall be prepared and agreed upon by all parties affected and recorded with the minor plat. I heard no other evidence that might lead to another condition of approval.
All right, commissioners. We have our framework on this. The floor is open for motions on the waiver. Ms. Nasser.
I'd like to make a motion to approve docket PZ 2310, the waiver to add an additional 4th parcel on the existing access based on the significance of the land tracts that are there and complying with the surrounding environments as well as the agreements set forth and the binding waiver set forth that there shall be a maintenance agreement included. Approved.
Thank you, Ms. Nestor. Council?
Sure.
Ms. Nasser, so one of the considerations on a waiver is hardship. So if you could talk maybe either about the inability to access the parcel in the back otherwise, or something like that, and add it to your motion, please.
The current access to one side is difficult in its nature, whereas the proposed access provides a much more appropriate access to this property as it currently exists and is being used.
That's sufficient, Mr. Chairman.
Mr. Council, we have a motion on the floor. Do I have a second? Mr. Falvey. Discussion. If there being none, we'll move to a roll call vote. Ms. Edgar?
Mr. Douglas, Mr. Elder, Mr. Ender, Mr. Falvey,
Yes.
Mr. Finney, Mr. Hampton,
Yes.
Ms. Jones,
Yes.
Mr. Winters, Mr. Klingenfuss, Ms. Nasser, Ms. Walzer, Mr. Marsh.
Thank you, Ms. Edgar. And the motion on the waiver carries by a vote of 12-0. Now we will move into consideration of the development plan.
So since you've agreed that the waiver is appropriate, there's a variance that's necessary. They've requested a road frontage variance for the lot. Its required road frontage is 300 feet. They're requesting 0, so the variance requested is 300 feet. There are sample motions for either approval or denial on page 3. Again, there's blanks. You can look at the motion and fill in the blanks based on the testimony you heard. And there's only one condition of approval. The road frontage variance will only apply to the application considered at the April 25th, 2023 Oldham County Planning Commission public hearing. You've already conditioned through the waiver everything else that's necessary.
All right, so I misspoke. This is a motion on the variance. Thank you, Mr. Urban. So the floor is now open for a motion on the variance. Ms. Nasser, thank you.
All right, I agree to approve the motion on the variance. the applicant is requesting from 300 feet to a zero road front variance based on the location of lot number one that has been approved and the hardships of getting to that lot. This approval is necessary, as well as creating a 300-foot variance for this lot would also disturb the area and change the environment of the surrounding properties to create that access.
Mr. Nasser, counsel,
Quit, sir.
motion on the floor. Do I have a second? Mr. Falvey? Discussion? Douglas?
Is there a condition of approval on this?
Yeah, it's just that the variance only applies to the plan that was submitted today.
So moved
So you'd like to incorporate that into your motion?
to incorporate that.
Mr. Falvey, is that acceptable to you as the second? Thank you. All right, all good. Fair enough. All right, let's move into a roll call vote. Ms. Edgar?
Mr. Douglas? Mr. Elder?
Yes.
Mr. Ender? Mr. Falvey? Mr. Finney? Mr. Hampton?
Yes.
Ms. Jones? Mr. Winters? Mr. Klingenfuss? Ms. Nasser? Ms. Walzer?
Yes.
Mr. Marsh?
Thank you, Ms. Edgar. And the motion on the variance carries by a motion of 12-0. Folks, you have your approval. Thank you. All right. We'll close that, and we will take a short break while we reset for the next docket item. Give us 10 minutes. Okay, we'll come back into session. We'll move into the next docket item. Ms. Edgar, will you please read the docket?
Docket PZ 23-011. An application has been filed by Meadowbrook LLC for the approval of a preliminary subdivision plan for 20 lots on approximately 86.7 acres to be known as Middlebrook. The property is located at 4800 South Highway 53, Ballardsville. The zoning is AG1 Agricultural District and C1 Commercial District.
Thank you, Ms. Edgar. And Mr. Fogel, you'll have the staff's presentation.
Good morning, Brian Fogel, Assistant Director, Oldham County Planning Development. The request in front of you all.
Mr. Klingenfuss.
Yes, I'll need to excuse myself. I rent this property. I have for a long period of time, so.
Thank you. Thank you for that. You are excused. Okay, Mr. Fogel. Sorry for the interruption.
The request before you guys today is a preliminary plat review and approval for a subdivision known as Middlebrook on South Highway 53 in the Ballardsville area. Notification on on all three, the county's website, adjoining property owners, and the Oldham Air were provided for today's hearing. The proposal is on an 86.67 acre parcel, and the applicants are proposing 22 building lots, and it's really 20, which we will get into as we talk about this, and then one open space lot. The location is in the Ballardsville area. Here's the new LaGrange exit. The existing LaGrange exit on 53 is right here. So if you travel south on 53, it's highlighted in red. The intersection of Highway 53 and Highway 22 are about right here. And as you travel south, it's right there highlighted in red. And just to provide you a little bit of a closer view, I'm gonna call it downtown Ballardsville. Downtown Ballardsville is right here. The former Board of Education building is the empty lot where Highway 22 and 53 come together. The Ballardsville Baptist Church is right here, and the proposed location is right here. You kind of see this key notch carved out. That's the existing house that's on the property. That as we get into the site history, it kind of relates to the construction of that house. But that particular house is not a part of today's request. The zoning in the area is primarily agricultural and residential. The notable difference is paralleling Highway 53 and 22 in the Ballardsville area. We do have some C1 zoning, which is reflected in the fact that you've got a convenience store at the intersection of 22 and 53, and a couple other mom and pop type operations in the area. The property, again, located right here in the commercial zoning along Highway 53. The site history on this property, prior to now, everything that's occurred on this in terms of any type of review by county government has gone before the County Board of Adjustment starting in November of '76, where there was a request by a veterinarian for a mobile home to be put on the property for the purpose of being a property caretaker. And then in '83, they came and requested a different mobile home to be used for an office for the veterinarian operation while a permanent horse barn was being built, which is still on the property, and it's a part of the request here. And then in 1988, a variance was approved to allow the creation of the parcel where you saw that house that was key notched out to be built, since it did not have any road frontage. In terms of things that directly apply to today's hearing. The applicants are here and they can speak to this. They had their first neighborhood meeting in January of this year. Based upon the feedback they got at that neighborhood meeting, they revised their plan, had a second neighborhood meeting in mid-February, and then in mid-March, the technical review committee reviewed the plat and provided comment for what is in front of you all today. Up to 22 building lots, and as we stated, there are a couple different zoning districts where the couple lots that are right up on 53 are zoned commercial, and then the remaining balance of the property is zoned agricultural residential. This is the plat, and we're going to go into different photos and zoom in here. Highway 53 is right here. They're proposing to build an access road called Middlebrook Drive that will go along the length of the property back to a hammerhead turnaround here. The commercial zoning roughly lies in this area here along Highway 53. You see a stripe here going through the middle of the property. That's a proposed future realignment of Highway 53, and we'll go into that detail here in just a second. And then there are two barns on the property. The barn that was being built while they had the temporary office with the mobile home is right there, and then there is a different barn right here that will need to be demolished and removed to allow the construction of the road, the subdivision road. All right, so where you saw on their plat, they have made provisions for the potential future realignment of Highway 53 that bisects the property. They have been working with the Kentucky Transportation Cabinet pretty actively and communicating with them to adjust the layout of their subdivision and set aside a potential reservation for a 10-year period of time that would allow for the extension of Highway 53. This is Kentucky Transportation Cabinet's environmental overview map from August of 2011. And the property we're talking about today is right here, this kind of grassy area there, so it stands out from the adjoining properties. And 53, you'll see, bisects the property right here. What you'll also see, which is not relevant because the Transportation Cabinet has decided not to go with that, is this other orange line here that would actually divide the property up into 3 sections instead of the proposed 2 sections, where Highway 22 may have been realigned to bisect this property. But what the Transportation Cabinet is going with is just to realign 53, where it will bisect the property right here. And highlighted in yellow is where the applicants have shown their willingness to set aside potential right-of-way for the realignment of Highway 53, right here. The applicant's engineer and surveyor have worked with the Kentucky Transportation Cabinet to determine the location of that, so then when they laid the lots out for the subdivision, they made sure that it kind of fit hand in glove. The two things went together. Kentucky Transportation Cabinet, as of right now, is saying that this is their timeline for the Highway 53 realignment. Now, all of us probably know transportation project deadlines are moving deadlines. So, these are subject to change. And interestingly, on the Transportation Cabinet's website, they put the asterisk to say, hey, this is subject to change. But right now, the proposal is to have construction of that Highway 53 realignment start in 2027.
Brian, if I can just interrupt and interject on that last slide. The cabinet has actually put out for bid engineering services. They've selected a consultant. To the best of my knowledge, they're still working on the scope of work and intend to give the engineers the notice to proceed in either May or June.
Okay, the applicants do have two barns on the property, one of which will be torn down. The other one they're proposing to leave as a community amenity on an open space lot. And that open space lot is highlighted in yellow right here. The yellow square is the barn that they're proposing to have remain to be a community amenity. And then this other barn would need to be torn down to accommodate the construction of the subdivision roads. I'm gonna go back okay, so here you see this is their road, Middlebrook Drive, coming back and terminating here. Here's the Highway 53 right-of-way. The length of this road is 3,200 feet. So our subdivision regulations say that when you have a road like that that dead ends into a cul-de-sac or a modified cul-de-sac like what they're proposing, it shouldn't be more than 1,200 feet in length. So one of the things in front of you all today, in addition to reviewing the preliminary plat, is a request for a waiver in the length of that street. In one of the application we just had, you know, you all discussed the waiver, and the subdivision regulations do authorize you all to grant waivers from the subdivision regulations when you determine that, you know, there are unique topographic or man-made physical conditions on that particular property. And then the findings that you all use to grant the waiver is that, you know, it's not a detriment to the public good, it doesn't impair the purposes of the subdivision regulations, and that it's desirable in the area. So in summary, you know, it's a request for preliminary plat approval on an 86.7 acre parcel for single-family residential lot with an open space. And, you know, suggested binding elements in addition to anything else the Planning Commission would determine through the course of today's hearing are there, and those have also been incorporated into your staff report. And that concludes the staff presentation. We can answer any questions you have.
Thank you, Mr. Fogel. So, first gentleman, okay.
Good morning, Jim Silliman, County Engineer, 100 West Jefferson Street. Get that to take up the full screen. So as we've led up to today, and Brian mentioned the various neighborhood meetings and the change in plan, number of lots being reduced, and the TRC meeting. We've had, when I say we, myself and Jim Urban and others have had extensive conversations with several of the adjoining property owners or nearby property owners with regard to their concern of stormwater and traffic and other matters typical to a modern subdivision development. Of course, the applicant is familiar with our stormwater construction runoff ordinances and post-construction runoff ordinances. Those will be incorporated into the construction plan review if this is approved and construction plans come to my office for review. I've noted on this sheet some of the permits that we, of course, would be requiring coordination from other agencies. That's the KYTC entrance permit, since they are encroaching on Kentucky Highway 53. Also the Oldham County Stormwater Quality Management and Erosion Control permit, which would incorporate the detention for stormwater and construction site runoff that I just discussed. There's also a blue line stream that's mapped on various sources. Because of that and the road crossing that and the development, we would require that the applicant also coordinate with the Army Corps of Engineers and the Division of Water for any necessary permits. They may not require permits. They may get correspondence stating that because of the limited impact that they don't, but we need to see that correspondence. Brian mentioned the Hammerhead Island. Some people question that because it's not a conventional cul-de-sac. At the TRC stage of review, there were no comments from or no adverse comments from emergency services. And those users, those are typically who I'm most concerned about being reviewing that cul-de-sac or hammerhead, because we want their large vehicles to be able to negotiate that, whether it's a fire truck, or an ambulance. And again, there were no adverse comments to the alternate hammerhead design versus a traditional cul-de-sac.
And Jim, we didn't hear anything from the Board of Education regarding school buses either.
That is correct. That's correct. During the TRC meeting, we also noted that there are mapped 3 potential wetlands, and those are on the USGS online viewer. I've discussed this with the applicant's engineer, and he's going to provide a little bit more information on those. I'll let him speak to that. Brian also mentioned the corridor for the proposed 53 realignment. On the TRC map, it was about a 250-foot swath that resulted in these proposed detention basin easements encroaching in that area. So the applicant's engineer has revised that to show a more reasonable 100-foot corridor for right-of-way, and the outer 75 feet are for land disturbance. So they would need to coordinate that again with construction plan design and review with the state to accommodate those basins. I think one notable point is that with the reduction of lots to 20 or 22 as it is now, it's a significantly less amount of impervious surface with a lot less rooftops. So they could potentially reduce the basin sizes and fit them more nicely in some of those basin easements. The only other note I had was I think it looks like if you look at our mapping on GIS, there's a line between the AG1 and the C1 that actually splits here, and that's not shown on here, but that can be revised. There's already a similar line at this location splitting that AG1 and C1. Just a brief summary of what we've observed.
All right, thank you, Mr. Silliman. All right, anything else from staff in this connection?
I just want to add to the conversation about the Kentucky Transportation Cabinet and the proposed realignment of Kentucky 53, and especially in relation to the wide swath going through this property. Back in 2011, a preliminary alignment study was completed, and that was not line and grade. It was just, if we're going to do this, here's about where it's going to go. And that's the intent of the Transportation Cabinet's hiring an engineer today, so that they can actually determine where and what is the best alignment for Kentucky 53. So that width was a maximum width. And so when there's an adjustment that Mr. Silliman just talked about in terms of the right-of-way width, there wasn't a proposed plan. And again, the alignment was just really lines on a map of where the road would go. So that will all be refined through the study by the Transportation Cabinet.
All right, thank you, Mr. Urban. So do we have questions for staff? Mr. Douglas? Mr. Finney? Does the addition or the proposal for the 53 alignment through there change the distance of the cul-de-sac? In other words, we got normally it's 1,200 feet, and now we've got actually an entrance in there off of a new 53. So now what does that make the distance difference?
That would be a good justification for approving a waiver for the length of that cul-de-sac, because if in fact 53 does get aligned, it does kind of split it almost in half.
Well, now
the distance would be changed dramatically. So yes.
So does that make a difference in that waiver we're asking for?
Well, it does if 53 gets aligned in this location.
Not today, we don't know that.
53 does not get realigned, doesn't get built, or they go beyond the 10 years that the applicant is willing to hold that right of way, then the waiver's appropriate, or it would still be in place. If we don't
egg thing.
Exactly. If we don't bisect the property with 53, then you have the total length of 3,200 feet.
What do you have, Mr. Finney? Mr. Douglas?
Yes, don't know if Jim can answer this or not, but maybe we'll start with him. Back to the realignment of 53. If 53 is realigned, what happens to, guess I'm looking at this, the opposite end from the curb or the cul-de-sac on 53 entrance? Does that become a stub road at that point, or does that 53 become, the old 53 become a frontage road because of all the,
And really, I think that goes to the final design of this whole realignment, but I think it would have to remain a frontage road for the people currently utilizing that.
The existing 53 will not go away because there are properties that access it. It would be, I'll call it old 53. So everything would stay the same.
school bus or fire department came in, even on the realignment of 53, they would be able to exit out Middlebrook onto the old Highway 53.
Yes.
Oh,
Closes that.
I think so. I mean, I can't predict the future, but
I don't foresee them closing it again because it has to remain for access to everybody else that's there. So I don't see any reason why they would close this Middlebrook Road.
and it provides access to so many properties, including the extension of 22. I can't imagine them making it private, so.
Why did the county decide to make it Middlebrook Drive and not Middlebrook Court? Since it's a,
Name these. I mean,
Don't name them. The applicant submits names to our GIS manager who looks to make sure that it's appropriate, and a court is typically a shorter road.
I guess my final, or one of the other questions I had was, when it comes to Middlebrook Drive, Court Road, whatever you're going to call it, is that a county road or a private road?
understanding is that they will design these to the county standards, so we would take them over as county road in the future.
So I know it's not required, but I can't see it on this. Is it curb and gutter?
The cross-section shows, I believe it shows a ditch section, correct?
60-foot wide right away with a curb. Yeah, he's circling it on the plan.
And you had a chance to look at, I guess it's too soon before the stormwater stuff and drainage or whatever the case may be.
Right. Again, those details will get hashed out in the construction plan review. We want to see that there's accommodations and adequate space for the basins, and they're situated appropriately between the streams, which is what's shown on the plan now.
And no sidewalks. I didn't see sidewalks, or we're not requiring it. Okay.
Shown on the typical section.
Appreciate it. Thank you.
Thank you, Mr. Douglas. Anyone else have questions for the staff? Sure.
I'm not sure if this should be for the staff or applicant, but is this, I'm looking at right across from Barrett's Auto Repair, the entrance?
We're pretty close.
It's pretty close. If you want to pull an aerial up, and it might answer your question or not. It's zoomed out there pretty far. I don't know if that answered your question or confused it.
I think I see it. So the entrance to the subdivision would be in the same spot as the driveway now?
I believe so, but I'm going to let the applicants answer
Let
that.
applicant answer those.
Yes.
Okay.
Yeah.
All right. All right. Further questions to staff? Mr. Douglas? Back to the well.
Go out and do a survey or look at and take any aerial photos or photos of the location.
No photos were taken of the location. To go out and look at it, yes. You know, the photo would be the driveway entrance on 53 because it stretches out back on the property.
Is there any consideration or discussion about in staff, Mr. Solomon can answer that too, on Highway 53, any blind spots coming in or out of the subdivision in that area because of the tight curves?
Earlier that Jim Urban and I had some extensive conversation with some of the neighbors, and that was one of their questions that they directed towards KYTC. And while KYTC is not here today, they did answer that there was sufficient site distance vertically and horizontally in emails that we received.
Right. And I know you just got the TRC minutes, but Transportation Cabinet was present at the TRC meeting, and they just talked about needing to make sure that the alignment of 53 is considered, and they didn't make any comment about the entrance.
Received emails regarding them?
Received an email from, I believe it was Johnny Micah at the time with District 5 permits. But again, their actual encroachment permit will come at a later date when they apply through KYTC.
An email that says the site distance is out of it.
Mr. Douglas, that all you have? Okay, anyone else? Questions of staff? All right, at this point, we will move into presentation from applicant. Mr. Swansburg.
Mr. Chairman, members of the commission, Mr. Urban, Mr. Baxter, Ms. Edgar, good morning again. Although I introduced myself previously this morning, for the purpose of the record, in this case, again, my name is Mike Swansburg, and I am a partner at the law firm of Swansburg and Smith. My office is here at 117 West Main Street in LaGrange. And I have the honor and privilege this morning of representing to you the Middlebrook LLC Development Group, which is proposing this preliminary plat, and the waiver has been talked about this morning. In addition to myself, we've got Bob Vincent here with, who's the engineer on this project. And Mr. Chairman, I know if we want to independently swear in again for Mr. Vincent, and also Walt Shum is here with Middlebrook. He may speak on behalf of the property as well. I'll be happy to have them be sworn in at this point in the event that they do have that testimony.
Please.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
Ladies and gentlemen, both Mr. Vogel and Mr. Silliman did an excellent job this morning summarizing the proposal that we are setting forth for you all to consider today. And I'm going to spend a little bit of time, I think, going over some generalities and really trying to focus on some of the areas that of concern, and also to kind of, from our perspective, set forth the rationale from a legal perspective and from a I guess, a philosophical perspective, if you will, why this plan makes sense and why it's good for the citizens here in Oldham County. I do want to take a real quick chance, if Commissioner Douglas mentioned this, the question about drive versus court. And it reminds me of one of my favorite stories. I was out in Las Vegas a number of years ago riding around with some friends, and we drive by a street which is called Frank Sinatra Drive. And I looked at the bus driver who was driving us around. I said, well, why did the city not call it Frank Sinatra Way to comport with the song My Way that Frank Sinatra sang, of course? And he thought that was pretty funny at the end of the day, but decided not to. So at the end of the day, Commissioner Douglas, the real answer is it was a personal preference on the part of the developers when they made the application. There's no real designation or significant basis for why it's one or the other, but that is the basis for it. This proposal, as discussed by Mr. Fogel, by the way, is not a quick and easy fly-by-night suggestion that has really been kind of put together at the last minute and then brought to you all for consideration. As Mr. Fogel mentioned, there have been multiple neighborhood meetings in support or in furtherance of this particular project. The idea was that at one time this was actually going to be a development that incorporated, I believe, 60 lots. And that was presented at a neighborhood meeting. There were some concerns raised at that time by the neighbors about the number of lots that were going to come in and the increase in traffic, in addition to the congestion otherwise that was going to be realized in that area. And at that time, the developers decided that they would take a look at it, and they revised the plan so that it was not just 60. Now you're talking 20 or 22, and I'll discuss that discrepancy here in a second. You're actually talking about 20 now anticipated residential lots from the original 60. And that is actually a design that was done in response to concerns raised by the neighborhood. And so the developers in this case have been extremely cognizant of the concerns and interests of those that in the properties that surround this proposed development, and have done their best to try to incorporate some of those concerns, where appropriate, of course, into this proposal. There was a an issue that was raised a little while back, actually relatively recently, and I want to talk about these really two things that we're talking about today in terms of presentation. One is for this waiver on this extension of the road, this long cul-de-sac that we talked about. That's one issue. And assuming for the sake of discussion that it is approved, of course, then we talk about approving the final preliminary plat overall. And so I want to get into first this idea of the cul-de-sac. And as was indicated before, the Oldham County subdivision regulations provide that a cul-de-sac is actually defined as under Oldham County Regulation or Subdivision Regulation 53C6D. Defines a cul-de-sac street to be, quote, have a permanently closed end. It also provides that cul-de-sac streets, quote, shall not exceed 1,200 feet in length. As Mr. Fogel pointed out, the anticipated or proposed street in this case right now is approximately 3,190 or 3,200 feet. So well in excess of that 1,200 foot maximum length that the regulations provide for. We've had a lot of discussion already about KY 53 and whether or not the Kentucky Transportation Cabinet is going to realign KY 53 to really split the project in the middle. So I want to talk about really two perspectives. One is, let's assume for the sake of discussion that never happens. That is a possibility, right? The Kentucky Transportation Cabinet may not, or may decide to go elsewhere, may decide to do something different. So let's suppose for the sake of discussion that never happens. That is why we are here this morning, is to seek a waiver for that in the event that it does not happen. We have 3,190 feet. So regulations provide that the commission may actually, where strict compliance, this is actually Oldham County Subdivision Regulation Section 9.1.a, provides that where strict compliance with these regulations would create an undue hardship because of exceptional topographic or other natural or man-made physical conditions encountered on the particular land, the commission may waive the requirements of the regulations to the extent necessary to relieve the undue hardship. And some of the considerations, of course, in that context also include whether it can be done without detriment to the public good, whether it can be done without impairing the purposes, basic objectives, and intent of the Oldham County subdivision regulations on the whole, and also without impairing the desirable general development of the neighborhood and the community at large. And I want to talk really quickly again about this concept that let's suppose KY 53 never happens and you've got 3,200 feet now. And is there a basis for granting a waiver from a legal perspective for that cul-de-sac? And we believe the answer to that is yes. And part of it, as you can see on the map, so it looks kind of like, in my opinion, the state of Pennsylvania with a little notch there at the bottom of it, but basically like the state of Pennsylvania. And as you can see on there right now, in the absence of KY 53, there is one means of ingress and egress to this subdivision, this proposed subdivision. That's right off KY, or the existing KY 53. Other than that, the entirety of the property is surrounded by existing development. There's no other frontage anywhere, or roads anywhere to which it may be connected to at this point. So there are, at this point, limitations on other available means of either connecting the end of that road to another point so it's no longer a cul-de-sac, or breaking it off and going down to another part of another existing road elsewhere, other than, again, that existing entry and exit way on KY 53. Let's see if I can do this. Yep, I can do this. All right, so this is where I'm talking about here, this entrance right here. That's the only means at this point of entering and exiting the proposed subdivision. Again, everything else surrounding it right now is existing property, existing development. So there isn't an opportunity for us from a man-made perspective to actually create any additional extensions on this proposed road. And somebody had asked before whether we're using the existing road. The answer to that is yes. At this point, we're contemplating, there's a driveway that runs the length of this property right now. We're essentially contemplating using that driveway and expanding upon it so that it makes the existing road. And Mr. Vincent can explain more detail from the technicality perspective, but from a general perspective, yes, that's what we're doing, is to minimize disruption to the land. We're using the existing driveway and expanding upon it. So again, there's a natural man-made issue that will prevent the at least prevent it connecting to other areas. In addition to that, and I'll have Mr. Vincent talk about this from a more specific technical perspective, the topography of the area also provides some limitations in terms of our ability to add on things like eyebrows or other turnarounds that may be incorporated into this otherwise. And what you will likely end up doing is resolving one problem, i.e. resolving the issue about the distance, and by extension creating additional problems. What do I mean by that? Potentially adding additional pavement or covering to the land such that you're going to have water runoff problems that were not originally contemplated as part of this proposal, and now become a problem simply because we had to add on additional pavement where we not otherwise contemplated at this point. Again, Mr. Vincent can talk about that from a very specific technical perspective, but there is some other additional problems with it in the event, again, that KY 53 does not in any way, shape, or form actually bisect the property. So we would submit that there are two legal bases for granting the waiver in the absence of KY 53 coming in. One is the natural man-made barriers that prevent us from creating any other means of attaching to an existing roadway. And then, of course, the land itself and the way the land is laid out from a topographic standpoint prevents us from doing it without completely disrupting the existing proposed land masses and ultimately frustrating the purpose, really, of the development as has been worked out extensively over time. And so, Bob, I don't know if you want to talk about that issue specifically from a technical perspective right now. Probably a good point to do that if you want to come up and talk about that, just really from the technical perspective on some of those limitations. What we'll go ahead and do is I want to bring up the second point, and then have Mr. Vincent actually just talk from one perspective rather than piecemealing this. So we talk about the possibility that KY 53 doesn't exist, and I talked before about what from our perspective, the bases might be for approving a waiver on that length of cul-de-sac regulation right now. But let's say that KY 53 in fact does come through as contemplated, and as you can see on the map, the developers have contemplated right-of-ways on this development, with the idea being that the Transportation Cabinet will build 53, and a question was asked whether it's going to bisect that and separate it in half, and the answer to that is more or less yes. But from a legal perspective, if KY 53 is built as contemplated on here, what the eastern half, or on the yellow line, the right side of the yellow line, by definition, no longer becomes a cul-de-sac. Why? Because you've got two connections at that point, right? So you've got an end here, and you've got an end here. So this part no longer is a cul-de-sac by definition. So that obviates any issue from that perspective. But what about the western half? If KY 53 actually goes through this section here, it will actually result in approximately, this side over here is going to be approximately 1,800 feet. So about 600 feet more than what the regulation contemplates, right? 1,200 feet for the regulation, 1,800 feet for this western half. But again, those same issues that we talked about before, it's the only means of coming in, the only means of coming out, and the topography are going to be inherently problematic with that western half, even if KY 53 comes in. You're still going to have significant problems with coming up with alternative plans for on both of those fronts from the western half of KY 53. So again, we would submit that regardless of whether KY 53 comes in, there is a legal basis for granting a waiver and allowing the development to proceed as contemplated in terms of the cul-de-sac road exceeding that 1,200-foot level. And even if, again, in conclusion, KY 53 does in fact bisect the property, we think that there's a legal basis. One, the right side or the eastern part no longer becomes a cul-de-sac, so the regulation is no longer relevant. And on the western half, those same concerns about the overall topography and limitations on the property will continue to exist for that western part. So that is the perspective on the waiver issue. So again, that's the first part that we want to talk about. And then the second part, of course, is overall the preliminary plat approval. I'm going to go ahead and jump right into that as well. So Oldham County Subdivision Regulation, Section 1.2, sub A through K, sets forth the intent of the subdivision regulations, right? And there's a listing of about 11 criteria for the subdivision regulations in terms of what ultimately is the goal of the regulations in terms of creating subdivisions here in Oldham County. And we believe, and I'm going to articulate for you here this morning, that we meet each of these criteria with this proposal. First off, I'd like to submit to you that the proposed Middlebrook subdivision promotes overall the public health and safety and welfare of the citizens of Oldham County because it, one, meets the existing, from our perspective, requirements, and that's the point of the regulation, is to promote the health, safety, welfare of the citizens of Oldham County. So that's why you set forth the regulations. To the extent we meet those regulations, which we submit that we do, then we are further promoting that ultimate goal. That's sub A. The proposed subdivision we would submit comports with the Oldham County Comprehensive Plan, particularly Land Use Objective LU 1-1, which relates to its compatibility with surrounding land uses, which are, quite frankly, similar to the proposed Middlebrook subdivision in terms of residential areas being around this proposed area at this point. Ag in nature, so that each of the proposed plots is going to be at least an acre up to 7.9 acres. It's going to have a larger field to each of the proposed land uses. That is going to comport with the surrounding areas, which also have a consistent agricultural, somewhat rural feel to them. In addition, Land Use Objective LU-2-1, which promotes connectivity between neighborhoods and compatibility with adjacent development. Again, similar to what I just mentioned, which is this idea that this subdivision, although a subdivision in and of itself, is going to, in many ways, have the same feel, the same connectivity to the surrounding areas, because it's trying to, and the developers have really tried to, in many ways, incorporate that overall feel, that semi-rural feel to all the areas around it with this particular development. So we think that it comports with the Oldham County Comprehensive Plan from at least those two perspectives as well. The Middlebrook subdivision also prevents overcrowding of the land and protects the character and social and economic stability of Oldham County and conserves the value of the land throughout Oldham County by retaining, again, its agricultural identity via these large land tracts, all of which exceed 1 acre. Again, anywhere between 1 acre and 7.9 acres, as you can see on the map. It maintains, again, that existing feel for the agriculture. It's not one big plot, I'll grant you that. But in terms of putting residential spots on there, the contemplated development is going to be such that it is minimizing the impact on the area, when otherwise it could be, again, the original contemplated proposal was 61 acre lots. They've gone through an extensive revision such that it really mirrors, as best we can tell, the areas around it. There's been no indication, as far as we know, from any of the utilities or agencies servicing this area that the proposed subdivision will either endanger or overburden existing transportation, water, sewage, drainage, recreation, or other public facilities to the extent appropriate. The subdivision is not going to hinder the proper circulation of traffic or create additional congestion within Oldham County, as far as we can tell. And there was some discussion earlier about the Kentucky Transportation Cabinets and the concerns about the visibility coming in and out of the subdivision. And the Transportation Cabinet has indicated that it meets, from their perspective, any concerns that might be relayed on that front. We would submit that the subdivision meets the reasonable standards for design of a subdivision, which is also part of the intent of the regulations, by incorporating proper lot sizes, set-offs, and required road frontage for the current zoning designations of Ag 1 and Commercial 1. We're not asking for you all to change anything from a zoning perspective, and we believe that the plan as presented today is going to meet the existing zoning requirements, which again is part of the intent of the regulations. Also, as I mentioned before, it's going to incorporate existing public facilities without placing an undue burden on the ability of those facilities to serve any of the surrounding areas. There's been no suggestion to us that this is going to create any kind of undue burden on any of the facilities or public services that are currently being served in that area. And also, to the extent that we can say this, the subdivision minimizes pollution and preserves the natural features for a proposed subdivision by incorporating, again, the use of large land tracts and additional remedial measures that Mr. Vincent can speak more to that are designed to really reduce the impact on the natural contours of the land in this area. So this is not going to be a massive area where the land is entirely raised. You're going to have issues with erosion runoff otherwise that are going to be an eyesore. Again, the idea is that it's trying to build a subdivision within an existing contemplated area and feel that we believe is already there and will be met by this particular proposal. That is all I have, Mr. Chairman, from a legal perspective, at least from what we believe meets in terms of the requirements for the Oldham County subdivision regulations. At this point, what I'm going to do is let Mr. Vincent come up and talk about some of the technicalities. And of course, at any time, if any of the members have any questions or concerns, be happy to address those as appropriate.
Thank you. Mr. Vincent, let's go ahead and get your name and address for the record again, if you don't mind.
Good morning again. It's Bob Vincent with Vincent Engineering and Land Surveying, 1000 Cherrywood Place, Suite 200. Again, good morning. Before you is the Middlebrook proposed subdivision. Middlebrook is located on Kentucky Highway 53, just south of its intersection with Kentucky Highway 22, or as Brian eloquently put, south of downtown Ballardsville. Lost Valley Estate subdivision is located on our northwest boundary.
You got a pointer?
I can't pointer. Oh, okay, there you go. Got it. Okay, thank you. Okay, so that is these 4 lots here. And then on the western boundary, that is a part of Locust Run subdivision. The property is zoned AG1 and a small portion is C1. The C1 border runs along here down to this corner. Lot 1 is entirely in C1, and we would like to continue to leave it in the C1 zoning classification, obviously. My clients feel like the best use of this property is in larger estate style lots ranging from 1 acre to 7.9 acres. And we are proposing 20 lots on the 87.6 acre tract. There is 5.1 acres in the road right-of-way. This includes the proposed realignment of Kentucky 53 that bisects the property. I know there was a question about the entrance. I did meet with Johnny Micah from the Kentucky Highway Department out there. We looked at it. The existing entrance that's there is on a bit of a ridge. It's a gravel entrance, and that is where we propose the new entrance. And there is adequate site distance according to them. That's not a determination that we make in any way, shape, or form. And also, I think it was previously stated that we do have to get an entrance permit from the Highway Department as well. It's a permit with design elements, and it's a big part of the construction plans. Okay. Again, it's been pretty well explained, but we are requesting a waiver of the Oldham County Planning Subdivision Regulation 5.3.6 letter D that states that cul-de-sac streets should not exceed 1,200 feet in length. The proposed realignment of Kentucky Highway 53 would create an intersection at approximately Station 14, not nearly cutting the cul-de-sac proposed road that we have in place in half. The remaining portion to the west would be approximately 1,700 feet in length, and we believe that additional eyebrows or turnarounds would only create more storm runoff because of the additional pavement and should not be necessary due to the relatively low volumes of traffic that these lots would generate. So, in other words, if the Highway 53 is created, that would generate basically just a connector road that would run from the intersection up to the existing Highway 53. And then to the west, we would have basically what will be defined as a cul-de-sac road that is approximately 1,700 feet in length. Topographically, there's not a great place to put in an eyebrow or a turnaround. Again, there's only really basically 9 lots that would be served by that cul-de-sac, and it's hard to justify a new turnaround because it would just be like a cul-de-sac bulb, which would be paved and increase the runoff, and just the 9 lots that are there, I don't believe would generate enough warrant for that to be necessary. There is a 0.8 acre open space that is defined here. Brian had it outlined earlier. There's a very nice existing horse barn that is here. The other barn that's there is basically just a run-in shed. It would be removed in the course of installing utilities and the road. The intent of the horse barn is so that the community, the owners, the lot owners could keep a horse there in theory if they wanted to. And then if they wanted to allow it to graze on their property during the day or what have you, they could do that. And then they could, of course, return the horse to the barn at night, potentially. Our net density is 4.08 acres per lot. So you can see with the 20 lots on the relatively large 87.6 acre tract that we're really trying to take advantage of the idea of larger estate size tracts. Again, the property is zoned AG1 and C1, commercial 1. Setbacks are 50 feet from the front, 15 on the side. However, we are going to require side setbacks of 30 feet. And the reason we're going to do that is per the Oldham County Subdivision Fire Protection Standard, section 7.3.f.1, that will change the requirements as far as fire protection. So if we do that, we will be in compliance. And I've talked to Russ Rose about that, and he's given us the okay to put that into place. The rear setback would be 40 feet. And those are what is required in the AG1 zoning district. Jim Silliman mentioned in his TRC staff report that there are 3 potential wetlands indicated on the USGS National Map Viewer. I was able to identify the locations as he had shown previously, and I staked them on the site. They are not indicated in the areas of proposed construction, but we will further evaluate those during the construction phase of this project. On-site storm drainage will be accommodated by roadside ditches. There will not be curb and gutter. And those will be directed towards the 2 detention basins that we are proposing here and here. We performed an overall site evaluation with Charlie Ward from the Oldham County Health Department, and we were pleased to say that most of the test pits were positive and would allow for traditional septic systems. All utilities are available, and water pressures and volumes have been confirmed again by the Oldham County Water District that allows for the required fire protection for the development. In summary, we're proposing 20 lots that are in keeping with the rural nature of the area. We believe this is the best use for the property, despite the fact that the AG1 zoning would allow us to have more than 3 times the number of proposed lots that we are proposing. Thank you for your time.
Mr. Vincent. Okay. Is there anyone else here who wishes to speak in favor of this application? Anyone wishing to speak in favor? All right. We'll move into testimony by those who are opposed to this application. Or questions? Thank you. Anyone wish to ask questions of the applicant or provide testimony in opposition? Please approach.
Not being dressed today. I forgot about this meeting.
Hey, let's go ahead and get your name and address for the record.
Call
And address.
4614 South Highway 53.
Hang tight, let's get you sworn in first.
Okay.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
Okay.
I'm not necessarily in opposition, but I am a property owner bordering this property and possibly 53 as well. I just have some points and possible questions. To the way that I've seen this explained is that it's possibly going to have 3 entrances. There would be 2 to the right and left of the future 53, and then the current entrance off of old 53. Is that correct?
If 53 is realigned through this property, yes.
So what Mr. Douglas said originally, I think, is a valid point, because why would they want to leave 3 entrances to a fairly small parcel of land? I would think you wouldn't want that many entrances off of 53 just for traffic situations. And why build a new road when we already have driveways and everything congesting the current 53? But that's just a point. And that leads into, we don't really know where 53 is going. The way it was explained to me is it's one-dimensional. They draw a straight line and say, in 10 years, this may be where 53 goes. Well, if you know anything about that topography there, it's very, very rolling. And I would think would have drainage issues. So we're 50, after the engineers actually lay out the new 53, I don't know how you could be this detailed with a subdivision when that 53 may move drastically. Can somebody answer that? Or like the timeline between the two?
Well, when the applicant first approached our office with a development plan, I realized that we had this, again, 2011 preliminary alignment plan. And we called the Transportation Cabinet, and their engineer and engineers from the Transportation Cabinet then got in communication, and the Transportation Cabinet sent a digital copy of the plan that they had, and that's what this alignment represents. That was done by engineers, and it took them a length of time to do that, and they understood the topography, and they were looking at potential alignments kind of throughout the corridor, either on the existing 53 or I'll call it cross country, a new route. And that aligns with a bigger plan. So I feel pretty confident based on the cabinet at least providing some information that they're in this corridor for a particular reason, because again, the topography, it even on that plan even has a 2-lane section for trucks to be able to climb up as you go north on this proposed road. So the only difference would be if I think the cabinet says either A, we're not going to do the project at all, or they're going to just widen the existing 53, which I'm not sure they'll do. Otherwise, I feel pretty confident that this is the alignment through this property.
So that's a little farther along than I understood. But if they do go with one of those other routes, do they have a plan for that easement through there? Say if 53 never comes through there, what's a long-term plan for such a large easement through there?
You can see on, it's hard to see on that, and I apologize, but there is a lot 21 and 22 inside that proposed easement that if the cabinet says, no, forget it, we're not going to do this, they have 2 lots. Yeah. And that's why they're saying it's a 22 lot proposed development. It'll be only 20 if the road comes through there.
Gotcha. So it is possible that that would be a very long cul-de-sac rather than it being split in half. That is a possibility then. I disagree with there not being, I guess there hasn't been opposition from the local services such as the fire department, the schools, and things like that, but that doesn't mean it doesn't exist. I live there. My kids went to Locust Grove and East. My son was the largest kindergarten class that Locust Grove ever had. So as he moved up in years, they had to move a teacher with his class. That school has been overwhelmed since the day it was built. So it's been over capacity since its existence. And so that these homes would contribute to all of that. And also, if you live in Oldham County, you know there's a bus driver issue. And I'm not sure about water, all of that sort of thing is actually a pretty big deal in Ballardsville. And I know that there are subdivisions that get planned. What I'm trying to, we live on top of the hill, Ballardsville, right off 53. That's on the hill. My property, I don't know if it's on an aquifer or something, but all of my neighbors and myself, we have water. We have had to have B-dry. We have had to have sump pumps. Even though we're on the hill, water is coming from somewhere constantly. During the rainy season, my entire 5 to 6 acres is marshy. You can walk out and it is literally marsh. And I'm assuming that's why this has always been good for agriculture and farming. So that I would think that everybody needs to think about what that's going to do with future building, because there's going to be massive amounts of runoff there, I would assume. And I am in the business. I'm an interior designer, and I've had clients in Middletown, actually. There was a subdivision, built a whole high-end subdivision, and within the first year, every basement had 5 feet of water. These were new $500,000 homes. And all of those homes, almost a huge percentage of those homes were sold again after the first 3 years because the builder did not foresee what was going to happen. So all those new homeowners flooded extensively. 5 feet of water is massive in a new built home. So I don't know. That's just a thing I'm throwing out there that really needs to be assessed. Because living there 10 years, there's a lot of water there. And my only other point is I'm not from Oldham County. We're all after the increase in property value because I don't have the heartstrings here than if I had grown up here. But we all moved to Oldham County for a reason. And losing farms and what we drive out of Louisville to achieve. You know, if you work in Louisville, you live out here for a reason. Just going forward, like he said, they're not asking for rezoning. This is all within the realm of what's already on the books. But going forward, you really got to think about what you want your county to look like, because Ballardsville is filling up with subdivisions, basically, and that's going to push this out. This is going to push the way you want to live out farther and farther. So that's just a point. I know Shelby County has went very, very strict on their planning and zoning, and I didn't buy there for that reason. It was too restrictive on what I wanted to do with my property. But then at the same point, Shelbyville's a lovely place to live. So I would think there needs to be a balance there, and this is going to be right in my backyard, so we'll see how that goes. I think that's all I had, and I appreciate your time.
Thank you. Anyone else wishing to speak in opposition or ask questions?
Good afternoon, or good morning. My name is Don Chesek, and I live at 5000 South Highway 53 in Ballardsville. Basically,
Lift that up so you don't have to hunch over. So there you go.
if I don't know if you guys can see this up here. Can you guys?
Let's get you sworn in before you get started.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And we all have displays in front of us so we can face you.
If you see the lower section, I own the entire property that borders this subdivision and beyond. So every speck of drainage from this subdivision heads south. It comes onto my property. I did not plan on coming up here to speak today at all. I was just going to listen. I'm not really for or against this subdivision, but I did want to clarify a few things that were said today. First of all, we only had 2 neighborhood meetings. I was at both of them. And at the first meeting, I specifically asked what type septic systems are going to be used in this subdivision, because there is no traditional sewer lines out this far in Oldham County. And what I was told at that meeting was they were going to use the new on-site 3-chamber systems. And I don't know if you guys are familiar with that, but that's, you have a trash tank, and then it moves over into an aerator tank, and then it moves over into a sanitation tank, which is either UV light or chlorine. And these have to be maintained by an outside professional business. They're attended 4 times a year, tested, all that. So the water coming out of these, pretty much almost drink from it, from what I hear from the state and the county experts on this. But that water has to be discharged at surface level. So it can't be piped underground or anything like that. It has to be discharged on the surface. And if it drains, it cannot drain across somebody else's property. Typically, when you put these in, they have to drain to a creek or some other area, not across someone else's property. I was just doing a quick Google search of where I live. I live right here. And I found 2 of these systems around my property. They were both traditional septic systems that needed repaired or replaced, and they put in the only option they could do. They put in these systems because the water or the soil in this area is very impermeable. It's basically clay, and also we have a very shallow vertical separation between bedrock and this clay. Matter of fact, the creeks running on my property that run off of this property, they're basically giant slabs of bedrock. They cannot go any deeper because bedrock is right at the surface. So the permeability of this area is very poor. So 2 of these systems were put in right next door to me, one across the street, one adjoining property owner south of me, because they didn't meet the requirements of a traditional system, and that's what they had to put in. I have another system that is a sand filter. It's to the north of me, because my property extends further than this property. So basically, on the same elevation of this subdivision, there is a sand filter system. Basically, you just dig a big hole, you fill it full of sand, and then you pump the effluent on top about 6 inches off, and it drips into this sand. And I'm telling you, it smells 365 days a year. There's another system across the road, and it's a lagoon system. And here again, it's because this property, this land it's just not good for drainage. So the reason I'm bringing all this stuff up is because at the first neighborhood meeting, I asked, what type of systems are you guys going to put in? They said we're going to be using the new on-site systems, this 3-chamber system, and we're going to be piping these underground to these detention basins. And I was like, I don't think you can do that. And I didn't know at the time, so I stayed silent. As soon as I got back home the next day, I started talking to the county folks. I talked to Charlie Ward. I talked to Greg Good, who's at the State Water. And I quickly found out that these systems are a last-ditch effort, and they're only granted on individual basis. So basically, you can't just go on a commercial level and put these systems in. It's against the law. And there was some opposition against that, but luckily that Greg Good, G-O-O-D-E, wrote an email to me, Jim Urban, Jim Silman, I think Charlie was on there as well, and he cited 2 different Kentucky state laws that basically you cannot put those systems in. So just for clarification, at the first neighborhood meeting, they were going to put in between 66 and 68 houses. And then, a lot of opposition from that. But the real reason why they went to the 20 to 22 was not because they listened to us. I guess they did. They listened to us. But it was basically because of these septic systems. It's just what they were proposing was not legal, if you will. So that's the reason it went to 20. I know Charlie did extensive research out there. They probably did 40 or 50 test holes. I saw them out there. I don't know the results of that in detail, although Charlie reassured me that they're going to make sure that everything's done correctly. But I do know that I talked before on the amount of bedrock, the permeability of the soil. It's just not inducive to septic systems. And the reason I'm concerned about all that is because I'm going to be on the receiving end. I have a honeybee farm. I have over 100 hives. I sell honey. I sell bees. I propagate bees all over the 4-county area. So to me, it is a concern because, and I have the rest of my properties all in wildlife refuge. I have 27 acres that runs this entire length of that subdivision I said before. So that's really why I came up here, just to let you guys know that that's kind of some of the real reasons from my perspective, what my personal thoughts are on as to why this all has evolved. But I also want to say that everyone involved, developers, county, all the folks, very professional throughout this whole ordeal. And I'm actually pleased that, this has come to what it's come to. 20 houses is a whole lot better than 66. And I'm the one who actually got a hold of John Micah from the State Transportation Department, and he wrote me a letter back and about visibility, everything's fine, it meets the standard. And I actually forwarded that on to Jim and Jim. So, we've all been working together on all of this. So I guess I'm not really for or against it, but I just wanted to make some points of clarification. So, and I thought, if I don't come up here and something does happen down the road, it's like, well, why didn't he talk about this, back when we were talking about this? So that's the reason why I came up. I wasn't prepared to speak about this, but I am concerned about drainage and, what may come my way. I'm sure I'll get a lot of different things that aren't coming my way now. Any kind of plastic paraphernalia, anything that floats on water, goes into a street, ends up into a storm sewer, into a detention basin, and then eventually flows across and gets caught in my creeks, whatever. That kind of stuff's going to happen. It's just how it works. But that's really all I want to talk about, I guess. So thank you.
Thank you, Mr. Tessie. All right, anyone else? Anyone else wishing to provide testimony in opposition, ask questions of the applicant? All right. Commissioners, how you holding up? Do we need to take a short break? Are you good? Everybody good? All right. We'll move into questioning from the commission. Who has questions? Mr. Marsh.
Related to the sewer system, did Mr. Ward check where the closest local or closest hookup in Oldham County would be?
These are on-site septic systems. There's no hookup. So,
but there's not one within half a mile of any,
it's not.
any of
Good
this?
question. It's not even close.
Excellent. Thank you.
Right. Mr. Douglas.
Thank you, Mr. Vincent. Couple of questions for you. According to, on the detention basins, it's proposed only if KYTC builds the alignment 53, or are they going to be?
That location is where we plan on constructing those detention basins. When we do construction plans, the size could be modified from what I'm showing on here, but that is the location. And I want to, if I can, clarify a little bit as far as where the detention basins are located. The yellow lines that are on here, that's 100-foot right of way. We're just showing that hasn't been proposed to us by KYTC, but that is the widest right of way that we've seen in Oldham County. If you look to the east and the west of those yellow lines, you'll see a significant area in there. From the far east line to the far west line is approximately 250 feet. The reason we made that 250 feet is because, not knowing for sure what the vertical alignment of the road is going to be, we have basically just set that in a set-aside area, if you will. so that if the fills are significant, that the toe of the slope would be contained in those areas. So again, if the road is not constructed, what you're seeing there on either side of the road that's being constructed on the north and the south would be 2 additional lots. That would be the entire width of those lots. Okay. So again, looking to the east of that potential line and the west of that potential line is the area where the detention basins will be located. They are located outside of the blue line stream. It's very difficult to do detention in a blue line stream based on the Corps of Engineers, but we have those in there, and with only 20 lots, we feel confident that we can accommodate not only the detention requirements that we have, but the storm water quality requirements that the county currently has in place.
You answered one of those questions for me, so I guess what I'm still looking for is that if the proposed realignment happens, and I did see the separation between the right-of-way and the detention basin, are you proposing adequate, and I don't know, I'm not an engineer, and I don't plan to be one, are you preserving enough for adequate to handle the drainage off that roadway also? Or are you just building it to the standards?
We're
talked about that with
you. Yeah, we at this point we have to address what we know, and that would be the subdivision. If there would be additional runoff that would be generated from the highway department, that's on the highway department. But we will handle what additional runoff there would be from our subdivision.
The highway or the HOA, if there is one there, responsibilities?
Those detention basins would be the responsibility of the homeowners association because they're outside of the road right. Not only are they outside the road right away, but again, we've got a set aside area that's 75 feet on each side of the road right away that, we're not encumbering.
And I didn't ask this to the county engineer, but are these detention basins just holding basins?
Yes. They'll be dry basins, yeah.
I guess I have one other question, and I don't know if the attorney can answer, but you might be able to answer. I noticed that track or lot 1 is pretty much existing or all C1.
Correct.
What are you building there?
I'm going to let the developer answer that question.
Not a residential, I guess.
I'm going to let him answer that question.
Because we haven't been explained that. We were told that there's going to be 20 lots residential or 22 lots if no KYTC. But we have 2 lots that are in C1, and I don't know of any rules that says that residential could be built in C1s.
Well, let me explain. The lot 1 is entirely in the commercial, okay? Lot 20, there's only a small portion that's actually commercial. It's to the east of the entrance road there, and that area that's commercial is not usable. You wouldn't be able to do anything there. But Walt, you want to?
Before you leave, though, before Walt comes up, he can talk about that. Lot, I believe it's lot 1 and 22 that's been set aside for the KYTC. What are the sizes of those lots? Because they're not on there.
Yeah, I did not put that on there. I can tell you approximately 22 is going to be in the neighborhood of 2 acres, and 21 is about 4 acres. Those aren't exact, but just by inspection, looking at the lots next to them, you can make that assumption.
Considered lot 22 part of the basin or outside the basin?
Basins are totally outside of lot
space
of the proposed lot 22. Yeah.
I guess the developer can answer the question about lot 1 then.
Mr. Shum, let's get your name and address for the record, please.
My name is Walt Shum. I'm the developer of this project, and my address is 1000 Cherrywood Place, Suite 300, LaGrange, Kentucky 40031. Thank you all for taking time today. In respect to your question, we expect to leave that zoning in place and at a future time decide if we're going to downzone it to residential. So we don't see that as a question for the commission today. We're not seeking zoning change. I would like to take a moment to tell you what our vision is for the property. We have set this up as large estate-style lots. Horses will be permitted on lots of appropriate size. We're leaving the barn for community service, whatever that may be. We're not going to define that, but it is a nice barn and will make a nice community area. We see relatively large houses and perhaps detached garages. This will be a very nice complement to what's going on in Ballardsville. As you approach the subdivision from the north, there's a lot of smaller lots leading up to this, and I think the preservation of these wide open spaces with minimal house intrusion will be very aesthetically appealing. The topography set up to allow for the large lots, one nearly 8 acres, many over 2 and 3 acres, and I see large estate-style homes on here, being only 20. In respect to an earlier comment by the gallery, we had the appropriate agencies from TRC out to give their comments on the property. This was handled in terms of septic by the Oldham County Health Department. We dug somewhere close to 50 different test holes on the property. We never proposed on-site sanitation systems throughout the whole site. That is told to us by the Oldham County Health Department. We like those systems for direct discharge, but that's completely controlled by a Division of Water in the Oldham County Health Department. The findings of the Oldham County Health Department were such that approximately 90% of the lots are available for standard septic systems. So I think that alleviates a question that you might have on capability. There are also large lots capable of the appropriate fields. I'll take any questions at this time you might have. We look forward and hope that you will see our vision and approve this subdivision as we've presented.
All right, further questions for Mr. Shum or the applicant?
Good morning. You say approximately 90% of the lots are available for typical septic systems. What are the other 10% going to need?
A percentage will be a system suggested to us by the Oldham County Health Department. And that could be a variety of mound systems, which are standard systems. It could be a direct discharge system. They will tell us what's appropriate for that lot in conjunction with Division of Water.
Okay, thank you.
All right, additional questions? Commission, Mr. Ender?
I had one. So I want to make sure that I'm clear on this. So, part of what you're all asking for is a waiver on the length of the road. So I just want to make sure I'm stating this clear. The topography of the land is inadequate to add any type of turnarounds to mitigate any of that distance.
The testimony has been that the topography is undulating and rolling, and that adding brows or turnarounds would be a burden, as is required by the subdivision regulations. We don't see any reason to put cuts into hillsides and create steep banks where they don't exist to do that, especially given the future plans for 53, which should neatly cut this subdivision almost in half. That itself, for a developer, is a challenge. And we think we've overcome that quite nicely with the large lots.
Okay, Mr. Ender, anything else? Okay, additional questions? All right, thank you, Mr. Shum. Oh, Mr. Urban, please.
Actually, for Bobby. Bobby, during your testimony, you mentioned something about setbacks, that the side yard setbacks were going to be increased. And you gave some reasoning that I'm not really clear of.
Let me get that. I've got. But it's, in generic terms, the subreg, under the Oldham County subdivision subregs, the fire protection standards, section 7.3.f.1. In that, it states that developments that are 1 acre or greater will meet a certain fire protection flow rate. I think it's 500. I don't have it, yeah, but that was proposed to us by Russ Rose. He said if we would do that, that we would meet the county regulation for fire protection standard.
Well, I'm really confused by that. I need to stop there for a minute because we have a fire flow requirement.
Right.
That I don't see how it's related. You said something about setbacks, that you increase the setbacks.
That's stated in the sub-regulation. It's 7.3, letter F, number 1.
That's in the zoning ordinance under the fire protection?
No, it's in the subdivision regulations.
Subdivision regulations. Hang on, I'll get it. Got it. Okay. So it says, single-family detached residential developments of 1 acre lot or larger with a minimum building, including accessory building setbacks of 30 feet from any property line, 500 gallons per minute, with a residual pressure of no less than 20 psi.
That's right. We, according to Russ, because I didn't do the hydrological calculations on it, he did. He said we will meet the standard if we agree to the 30-foot setback, which is less than is required in AG1 in the front and the rear, but more on the sides. Since we have the larger lots, that's no problem whatsoever.
Have any communication from Russ regarding that? I don't recall seeing a hydrologic analysis or anything. Is that something that you can provide us?
Don't, but we do have, he was here at TRC and that was his testimony, was that.
And these are only minutes from the TRC. I don't see that in our minutes, and I forget things, so I don't remember that being a discussion during the TRC.
I'm not going to say that we discussed it at TRC. I'm not 100% sure.
I just want the commission to be aware of this. We had another case, as you know, that we had to grapple with firefighting, and want to be really clear about this. Ability to provide the necessary fire flow.
Right. But again, I can testify that I've had that conversation with Russ, and he has assured us that that is, we can meet those standards as long as we'll do what it says with the 30-foot sideline setback.
Mr. Urban? Is that going to be something you can move forward with, or do we need to?
I have a question for council. I mean, AG1 states that our setbacks, what, 40 feet? Max.
Well, there's a minimum setback. You can make it greater. You can always make the setback greater.
But we're going less than 40 feet.
No, he's talking about, this says
30 feet.
30, but it doesn't specify whether it's side yards or front yard. And what he said is that they're increasing and making sure the side yard setbacks. The front yard setback in AG, hang on a second here. I'm going to not use my memory.
Minimum side yard setbacks 15 feet. And that's, are you proposing, I guess you got to come back up here.
Well, the minimum front yard setback. The minimum front yard setback in AG is 50 feet. So that's greater than 30. And the minimum side yard setback is 15 feet. And I think you testified you were going to make it 30, the minimum side yard, so that it would meet that requirement from all setbacks.
Right, the rear is 40, and as the AG1 zoning. So we'll be more than
It's from, it does say from any property line. That's correct. So they're just saying they're going to comply with that requirement and be able to meet the 500 gallons per minute. My question is, I didn't see any of that from Oldham County Water District. Other than, and I believe Mr. Vincennes under oath, I believe he says something under oath that he's had a conversation. We don't have any.
I mean, you do have in the minutes that Russ stated that we will meet the fire requirement.
Again, the minutes aren't necessarily everything that was said, but the high points. And the only thing from the TRC minutes, and this is for the March 15th meeting, which was for the 20 lots, he said, a review by Oldham County Water District is required prior to the approval of construction plans. And the second bullet point is facilities installed will not become property of the Oldham County Water District after all necessary easements are recorded. It doesn't say anything in our minutes about this.
Okay.
Now, whether it was said during the meeting, I don't remember, but our minutes don't reflect that. So I want to just be absolutely certain, because we've had issue with fire protection in the past, and that was appealed. So I want to make sure that we're making the right decision based on the right information.
So,
I'm being overly fussy about it, but I think I need to be.
so why not recess for 5-10 minutes, have staff contact either somebody to find out.
Answer that question, right?
If you want to.
All right. Okay, we'll recess. We'll make it 10. Okay. Stop the clock up there.
But I mean, they don't approve this.
I'm going to call him. Yeah, I'll call him. I'll see if I can get him up here.
Lost Mr. Calder.
don't know. I don't know.
You might as well come down here. We're gonna put you on. Wait, we're just waiting for him to get the.
Wait for the system to boot up, and then we'll go.
Okay, we're good.
Okay. All right. Thank you, everyone. We'll come back to order now. So you guys may have noticed we lost two commissioners at our break. We've lost Mr. Hampton and Mr. Elder, and we'll proceed in their absence. Fortunately, we have Mr. Rose present now to address some of the questions we've been raising. So, Mr. Urban, I'll throw it to you. Mr. Rose, if you will approach. Oh, I suppose we'll need to get your name and address and get you sworn in.
Russ Rose, the CEO for the Oldham County Water District, 2160 Spencer Court, LaGrange.
So, Russ, what we've asked you to come here to clarify.
I'm out. Let's get him sworn in, please.
Do you solemnly, raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So the question came up in presentation about Middlebrook subdivision, which is what we're discussing here this morning. Mr. Vince Hand made a statement that I needed clarification on, to be sure. In our regulations, the subdivision regulations under fire flow, there's a statement that says single-family detached residential developments of 1 acre lot or larger with a minimum building, including accessory building setback of 30 feet from any property line. The fire flow requirement is 500 gallons per minute with a residual pressure of 21 psi minimum. And we didn't have anything in our TRC or anything in our application or anything supporting that. You are able to provide a minimum of 500 gallons per minute from the Oldham County Water District.
And yes.
You pull the microphone up and say it a little louder, just.
We can, yes.
Thank you. Okay. And was that based on a typical hydrologic analysis?
It was based on our hydraulic model. So pressure ranges on a normal day-to-day out there will be between 54 and 77 psi. And we would have fire flow in excess of 500 gallons per minute.
Really, that's all I needed to hear. I don't know if any other commissioners needed to hear anything.
Other questions for Mr. Rose while he's present, commissioners? Mr. Douglas, sure.
Now that I have you here, is there a different GPM for commercial?
Commercial?
Huh? It's a single family.
Well, in the regulation, it says commercial, industrial, and institutional developments may require additional fire flow depending upon the occupancy, construction, and fire protection features. So we don't know what's going to be on Lot 1, but it would be addressed should Lot 1 be developed.
Future. That sounds good. Thank you.
Okay. Is that all you have, Mr. Douglas? Anyone else? All right, Mr. Rose, we appreciate you making the trip to see us.
I know it was quick and short. I appreciate you being here.
We are still in the section of questions from the commission. Mr. Marsh?
Yes. I have a clarifying question, please. I believe it's for staff. Charlie Ward, Oldham County, in the TRC review said a site evaluation will be performed on each lot for the specific location of the on-site sewage disposal septic systems before a building permit is issued. So if we approve this, we're saying that no construction would start until a building permit is issued and it meets all of the Oldham County and state regulations, correct?
Correct, and that's standard. It doesn't matter where you are. If you're on a on-site septic, it requires the health department's letter before we issue a building permit in any situation.
Thank you.
Mr. Marsh, anything additional?
No, sir.
All right. Other questions from the commission? Mr. Falvey.
And this is more curious. There's a lot that doesn't seem to have access, not part of this development. It's between lot 13 and 16. Was that that must have been an existing property that had access to this property at some point?
That's the notch in Pennsylvania.
Yeah, I got my arrow there. So this is the property that
Uh-huh.
you're talking about. Yes, there's an existing home that's there. There's an existing access easement that goes along the driveway. That house in approximately 3 acres was sold
What?
at some point in the past. I'm sorry. Yes.
Oh, to this existing people, or
The current owner, it was sold to them a couple years ago. Yes.
and so their access currently is this
Driveway, which runs essentially in the center of the right of way that we're showing. And there's an access maintenance agreement that was created when that lot was created.
Okay.
So what happens when we build the road? Well, they'll get access, and if you look closely on there, there is a 30-foot access easement. I just
went away.
Okay. There you go. All right, yeah, so where Brian is pointing at, there's a 30-foot proposed access easement, so they'll have access to their property.
And you all have that access, they've agreed to your access.
I can't say that they've agreed, but as long as we give them access, that
It'll be the same thing they had.
the same thing, yeah.
Okay.
There you have Mr. Falvey. Anyone else? Questions? Okay. We'll close the question by the commission and move into rebuttal evidence from the applicant. Mr. Swansberg.
I'm not sure whether or not, for the purpose of rebuttal, there was anything.
Let's get, there you go.
Heights of individuals, so I'll go ahead and make sure I'm properly mic'd up here. Mr. Chair, members of the committee, what I would submit is that what I did not hear really was any affirmative argument on the part of any of the commenters in opposition to or questioning really any of the other than those that we've discussed in length here with Mr. Rose, et cetera. So there's not, I would submit, there's not really anything to rebut per se, other than simply reaffirming our position, which I'll be glad to do as part of our closing. But again, we believe that the concerns that were raised throughout the question period were addressed. And again, we'll make the argument in our closing as to the rationales for why our two requests are warranted. But at this time, I don't have any other reason to rebut per se, again, anything that was raised by anyone in opposition.
Thank you, Mr. Swansberg. For those who have provided opposition testimony and questions, do either of you have any rebuttal comment to make?
Just hearing further details about the future of the development. The way I understand I think we can all agree this is going to be multi-million-dollar homes. He's creating an absolutely lovely community that people are going to love to be there, especially with horses, and with providing horse stables and everything that their HOA pays for on the left of this community. People to the right of this community are going to want to access all that they are paying for. So I'm foreseeing that being an issue with horse owners crossing straight across Highway 53 when we've already had issues at the Ernie Harris Parkway when traffic wants to go straight across. I'm assuming when you build new 53, you're going to want that to have a higher speed limit, less turnoffs, a more straight through thoroughfare. So to have a subdivision of that caliber and residents paying that amount of money to have their community split right down the middle If I were a developer, my next step would be to fight where 53 grows. There's a lot of, there would be a lot of pros to not having 53 cut that neighborhood in half. And so if a person of clout thought that and 53 ended up going somewhere else, then you have really a nice community with one access. And honestly, as a person who lives there, I don't have that much opposition to that. But as also a person that lives there, if that's the best place for 53 to be placed, I would hate for this subdivision to come in opposition to that. And I still have a big issue with the fire department. That fire department, to my knowledge, is mostly volunteer. You have a lot of young people, a lot of young men who want to provide fire protection for their small community. My biggest question, my dad and my brother were volunteer firemen. Are those firemen trained to fight 10,000 square foot plus homes? That is a major undertaking for a small volunteer fire department. And my last point is that's expected to be a county road. We all know if you don't build that road from the beginning with the correct drainage put in, that's going to be a taxpayer problem. That's ice removal, snow removal on both sides. It's falling land. If that doesn't have access drainage, that's going to be a county problem and a taxpayer expense. To go in and redo a subdivision road that they expect you to make a county road. So as a taxpayer, that is a big problem for me. Thank you.
Thank you. Anyone else? All right. Anyone from the opposition wish to provide a final statement? Anything to add? You have not provided previous testimony, I'm sorry. All right. We're down to final statement from the applicant.
Final statement.
Nobody who's given testimony wanted to make a statement. Correct. Mm-hmm.
I've said final statement.
Mr. Swansburg.
Chairman, members of the commission, I want to thank you all again this morning and this afternoon for allowing us to again present this proposal to you all and to share, as Mr. Shum said, our vision for the Middlebrook subdivision. We talked before again about really there being two issues that we are asking for you all to consider, both of which have been talked about at length. One is the initial one, again, this waiver of the roadway that we're talking about in excess of the cul-de-sac regulations under the Oldham County subdivision regulations. And what we believe we've talked about before or today in terms of why or as a legal basis for you all approving this, of course, is twofold. One is, again, in the absence of KY 53 even being in there, which is at this point what you all can consider based upon what is in fact present now, is that there are at least two reasons why we believe that a waiver is warranted. One of which is, again, this idea that the entire property, except for one area that has in fact been designated for entrance and exit, is entirely encompassed by existing development and cannot, the developers cannot in fact create another means of either addressing or closing off that road other than simply utilizing the existing streetway. And then in addition to that, as been talked about before, on behalf of the plan, is that the topography and the existing terrain in the proposed area is not conducive to creating additional paved areas for things like eyebrows or turnarounds without gutting into existing land areas and creating, again, what we would say is collateral problems like runoff and other resulting problems that may be at this point unanticipated but could become realized by virtue of that attempt to address that problem in the future. So we think that there is in fact a basis for a waiver at this point of the regulation. Of course, if KY 53 does in fact intersect, that negates, at least from a legal perspective, the east side of the property, which is no longer a cul-de-sac by regulation. So the issue becomes moot for them. On the western side, again, that land, the limitations on the property as well as topography limits the ability of the developers to do anything with it other than what is contemplated with this at this point, and we believe that that is an appropriate means for approving a waiver as well. Just like it did earlier today, I hope with the indulgence and of course the approval of the county attorney, I have a proposed motion to approve the waiver of the regulation that sets forth again the legal basis for a waiver under the regulations, in addition to the criteria for what the commission should consider when considering a waiver on this basis. And we believe that the motion satisfies the needs of a waiver pursuant to the regulations and based on the testimony that has been presented here today. So I would ask you all to consider that when you are considering a motion for that purpose. In addition to that, that's the first part. Second part, of course, is the general request for you all to approve the preliminary plat for the subdivision on the whole. And I want to just again reiterate this idea that we've got some developers in this case who really took a lot of time and effort to reach out to to meet with the community, to talk with the community members and neighbors about their concerns, which were talked about today as part of the testimony on both sides, and that they attempted to try to incorporate as much as possible those concerns into this plan. It has been revised from its original plan of 60 lots down to 20 lots to accommodate, again, the concerns of the neighbors, in addition to really trying to get more along the lines of that semi-rural area, the semi-rural feel of that area as it is already, so it is consistent with and be aesthetically pleasing to, as Mr. Chum said, the area and the residents and individuals who may otherwise bisect that area in terms of traveling. So there's been a lot of effort on that front. Again, I have taken the liberty of putting together a request or a motion to approve the waiver of the preliminary plat. This document takes into account, again, the intent set forth in the Oldham County subdivision regulations, those 11 items that I talked about in terms of the intent or purpose of the regulations and how, from our perspective, this preliminary plat request meets those. And so if I may, Mr. Vogel, thank you, I appreciate that. Again, the idea about the use of large tracts, we're not asking for a zoning variance in any way, shape, or form, or zoning change. We believe at the end of the day, this proposal as presented, in fact, meets the criteria for a approval on this front. I just want to go ahead and make sure that I state for the record that the developers have every intent, assuming that this plot is in fact approved, the developers have every intent of complying with every state, federal, and local requirement to actually construct the residences on this plot.
Mr. Swansburg, we are running out of time.
And so since my time is on the way of expiring, I appreciate again your time and ask for you all to respectfully approve both the waiver and the preliminary plat as presented.
Thank you. Okay, so let's move into deliberations. Mr. Urban, can you frame this up for us?
You actually have two decisions, and the way the staff report is written, it might be a little different than you normally do. Brian did this. You can consider the waiver and the subdivision, preliminary subdivision plan all in once. I've asked Mr. Baxter about it, and he agrees you could do it that way, or you can take the motion separately. You have been given a potential motion for a waiver and a separate one for preliminary plat, if you so choose to consider approving this development. As always, there's a sample motion in your staff report regarding a motion to either approve or deny. If you are inclined to approve the waiver and the preliminary subdivision plan, there's binding elements that are proposed. The first is that there shall be no major changes to the Middlebrook preliminary plat as presented at the April 25th, 2023 Oldham County Planning Commission public hearing without review and approval of the Planning Commission. The Middlebrook preliminary plat and construction plans must comply with all established federal, state, and county ordinances and requirements at the time of the approval, and the record plat will not be approved until all standards are satisfied. The third is the 250-foot wide proposed KYTC right-of-way for the potential Kentucky 53 realignment will be held in reserve for a 10-year period of time beginning the date of the initial Middlebrook record plat recording or by separate agreement with the Kentucky Transportation Cabinet. The fourth one, I actually have to ask Brian about this. It says entrance driveways, curb cuts for lots 1 and 20 shall be directly from Middlebrook Drive instead of Highway 53. I'm not sure whether that is a good thing if it were to be developed commercially. While he's getting up there, the fifth one I've added is that the number of building permits per year is 25. The maximum number of building permits is 25 per year starting at the time of the first record plat. That was in the TRC notes and submitted by the Oldham County Board of Education.
Real quick, a point of clarification. That should be a 100-foot right-of-way with a 250-foot area of disturbed limits. So it's a 100-foot right-of-way, not 250 feet.
And the one on the lot number 1 only have an access from Middlebrook. I mean, if it were commercial, that they may consider getting approval from the Transportation Cabinet for a commercial curb cut. Walt, did you hear these and agree to that? That it's okay? So I'm going to modify this number 4. Actually, I think we can
just strike 4.
We can just strike 4.
Right.
Yeah. But there are actually only 4. For clarification, do I need to restate them?
Yes, please.
Okay, so the first one is no major changes without coming back to the commission. The second is must comply with all established federal, state, and county ordinances. The third is that the 100-foot wide right-of-way with 250-foot disturb limits for the potential Highway 53 realignment. The rest is the same. And then the fourth is that the maximum number of building permits is 25 per year starting at the time of the first record plat.
All right, everybody clear? Council?
Mr. Chairman, the only comment I would make, and so I know a lot of times we consider the waiver separate and apart from the development plan. And my only thought, and Mr. Urban and I discussed this, is that the development plan doesn't work without the waiver. So the waiver is integral to the development plan. So if a person wanted to make a motion to approve, and that would include both the waiver and the development plan, I have no issue with that. But if somebody chooses to make a motion on the waiver only and then go to the development plan, that's acceptable as well.
Very well. All right, I hope everybody's clear on that. Given that we are doing this just a little bit differently, we have time for questions. Should you have, before we move into motion making, Mr. Douglas?
I don't think, I think I could probably answer my own question, but I believe there was an access that someone raised to gain access to the other property. Is that needed to be in a binding element that?
You're talking about that one lot that's
that's going to have an access?
I don't think they'd, I'm sure you wouldn't object to requiring a, well, that's a.
It's on lot 13, I believe.
Cross lot 13. So yeah, I think we can add a binding element that says that you must have a shared access and maintenance agreement for that lot that's actually not part of this subdivision, that 3-acre lot. That driveway goes across lot 13. It's pretty typical for us to require describe who maintains it if it's on somebody else's lot. So that binding element would read, I'll pin it real quickly, an access and maintenance, an access easement and maintenance agreement must be submitted with record plat. and it's not described as a lot, and I can't see the ownership of that lot. We all know which one we're talking about.
Clear enough? All right. Any additional questions? All right, we will now open the floor for motions. Mr. Ender.
I move to approve applicant PZ-23-011, the Middlebrook preliminary plat and cul-de-sac length waiver because it is in accordance with the purpose and intent of Oldham County subdivision regulations. The Middlebrook preliminary plat specifically satisfies the following purposes outlined in the Oldham County subdivision regulations: protects and provides for public health, safety, general welfare of Oldham County, protects the character and social economic stability of Oldham County while encouraging orderly, beneficial development, protects and conserves the value of the land throughout Oldham County and the value of buildings and improvement upon the land, and minimizes the conflicts among the uses of land and buildings, and provides the most beneficial relationship between the developing uses of land and buildings and the circulation of traffic throughout Oldham County, and having particular regard to the avoidance of congestion in streets and highways, and ensures the public facilities are available to have sufficient capacity to serve the proposed subdivision upon its completion. I would also like to include all 5 potential binding elements as stated by Mr. Urban.
Mr. Baxter?
Sir, if you could include a section of the comprehensive plan that you think is applicable, and as it relates to the waiver, there is some justifications for the waiver, if you might list a justification for the waiver. I would comment that the motion uses the language of LU-1-1 and LU-2-1. So I believe he has referenced that, although he did not cite the specific sections of the comprehensive plan. I think he referenced those things. So,
Mr. Ender may wish to incorporate that into his motion. Is that so?
So.
And with respect to the waiver, does that answer?
With respect to the waiver, the conditions, the basis for the waiver, I guess, is the reasoning that you think it's appropriate. Correct. Yeah.
So, do we have?
We do have an adequate motion, sir.
Motion. Okay, we have a motion on the floor. May I have a second? Mr. Marsh? Thank you. Discussion? Quiet. All right. Edgar will do roll call vote, please.
Mr. Marsh?
Yes.
Ms. Walzer?
Yes.
Ms. Nasser? Yes. Mr. Winters? Ms. Jones? Mr. Finney?
Yes.
Mr. Falvey?
Yes.
Mr. Ender? Mr. Douglas?
And motion carries on a vote of 9-0. You have your approval. Sorry? I've got 9.
Some people that left.
We lost Mr. Elder and Mr. Klingenfuss as well. Did not vote on this. So come to 9 on that. Here, keep that or I'll lose it. Okay, commissioners. Next order of business. Where are we, Mr. Urban?
We need a motion to go into executive session, and Barry is going to give us the citing from the regulation. Oh, I'm sorry. Yeah, I'm sorry.
I'm going to take care of the.
I got my agenda back.
Okay.
Yeah.
It's in the way.
At the last planning commission hearing, you had the authority and pleasure of appointing 2 people whose terms had expired, and the judge's office, because of changes, had there was a lapse. Will Douglas and to the Planning Commission, Charlie Ward to the Board of Adjustments. In that appointment, we didn't state their terms, so we just want to affirm the appointments of Will Douglas. His term is to expire October 7th, 2026. To the Planning Commission, and Charlie Ward to the Board of Adjustments, and his term is to expire January 1st, 2027. So I just need a motion to affirm those appointments in that.
Any questions, Mr. Falvey?
I'll make that motion.
Please. Is that adequate, Mr. Counsel?
It's adequate.
Thank you. All right, we'll move into a roll call, or excuse me, we'll take this by voice vote. All in favor, please signify by saying aye. Opposed, like sign.
One abstention.
And abstentions. Thank you. Please note that Mr. Douglas has abstained. All right, next order of business, Mr. Urban.
Mr. Chairman, we need to go have a motion to go into executive session pursuant to KRS 61.815 sub 2 to discuss 2 pending legal matters.
All right, let's get a motion on the floor. Mr. Finney.
I move we move into executive session.
Thank you. I have a motion on the floor. Do we have a second? Mr. Falvey, thank you. We are now in executive session.
I think we need to